Hello.
Page wise mentions. Page number 1, item numbers 4 to 15. Page number 2, item number 16 to 25. Page number 3, item numbers 26 to 42. Page number 4, item numbers 43 to 59. Page number 5, item number 60 to 62. Page number 6, item number 63 to 77.
Second week, Monday.
Page number 7, item number 78 to 83. Page number 8, item numbers 84 to 98. Page number 9, item numbers 99 to 110. Page number 10, item numbers 111 to 127.
Tomorrow, the urgent motions. Next matter. So let's change. Let's share that with the tomorrow is the urgent motion.
Item number 36.
Yeah. So it will be closed. Learned counsel, the petition submitted with the grievance of the petitioner has been considered and allowed, and therefore no further orders are necessary in this petition. Dismissed.
Motion list, item number 1, for pronouncement of judgment, Ajay Kumar, Rohit.
I think 217. The concepts before location and credited to the matter proceeding court. Taking the various signature college not to pay. But government consent has been set up. So I thought my senior counsel to government should ask me the matter. 230. Before location. Any day.
It will reach, sir, this week or two, next week it will reach.
Item 194, may you write me covered matter, matter pertaining to recruitment to the post of training as a teacher. DGM is also confirmed that DGM is also confirmed they implemented in so far as that particular case is concerned. Matter
No, whenever it reaches, yes.
Item number 1, for pronouncement of judgment, Ajay Kumar, Rohit.
TRC is dismissed. Eight.
Sorry, Yala. Eight.
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 Item number 2, Srinivas, Lakshmi Manohar.
TRP is dismissed.
Item number 3, Ramchandra Reddy, Chief of Service.
My lord, I may be permitted to withdraw this petition, my lords, the lordship.
Yes. Are you seeking any liberty? No.
No, your lordship may dismiss. The other matters are dismissed already day before yesterday, my lords. This matter also may be withdrawn.
Dismissed as withdrawn.
Much obliged, my lords.
Item number 4, Shashank.
Challenging the promotion to fourth respondent.
Promoted on paid document.
Fifth respondent. So how are you going to benefit? You are already retired. You have already, you are already 61 years of age. You are a retired employee. What is the date of promotion of that person? You are asking for, you are challenging 29/1/2013 order now.
Myself and other employees were responded. Making on representation, but they are not considered. When the matter was brought to the notice of the commissioner with the consent of the duty officer, they referred back to the Vigilance and Enforcement Directorate. Even then, there is no action taken. You ask me kindly see the promotion of this first page, first time, right? Without considering seniority of the physician and elegant respondent other employees, only in due consideration of the representation submitted by fifth respondent, not by the senior paid by the department.
Where are your representations?
Latest several representations I myself and other employees were affected to the promotion of the fifth respondent for fine.
How is the fourth respondent here responsible here, Director General of Police?
Because the matter was referred to the Vigilance and Enforcement Department by conducting inquiry. No inquiry was conducted.
Where is that reference?
Reference I did not get relaxed as the
Then?
officer regard. The letter addressed by the Raja Temple.
No, where is your representation at the earliest when you made a representation? 2013 is the promotion order you are challenging here. You say you have been making representations. Show me, point out to be one representation.
This is the letter addressed by the officer to the controller of examination, Periyar University, Sangan, Tamil Nadu State.
40,
42.
42, 41. 42 is the Rajarashtra Swami Devasthanam.
Addressed by the executive officer
To
to the controller of examination, Periyar University, Salem, Tamil Nadu.
Okay.
Asking them to issue the medical marks certificate and the provisional certificate. And the document certificate produced by him, which is part for party, which related to Lalita University, which is at Bihar. Without entertaining any suspicion, the executive officer promoted him as the representation filed by the respondent.
Where is your representation, sir?
2021.
When did you retire?
28.
When did you retire? Hmm?
58. That is prison 58.
58.
8. Highlight one month. Submission matter. Mr. Expert,
When did you retire from service, sir?
matter on 2022. The fact is that the fifth petitioner was appointed as an MR. And he was posted in the Rajraj. Thereafter, he was transferred to Telangana Kalyana Mandapam, and he has not resigned there. He was absent. Not able to get the place he was transferred. Thereafter, he was removed from service. And the fifth respondent approached the Sarabhu court, and the Sarabhu court passed.
Unless until you show me that you will be the beneficiary by sitting aside his promotion order and that you have been agitating it earlier, I will not interfere. Okay, after retirement, you make some representation and then now you are challenging the fifth respondent promotion at this stage.
Because the senior which I filed in the petition proved that his name was there, not in the seniority.
Why did you not agitate earlier?
I have submitted so many objections.
Where are they? Right. 19. Page number 19.
19, but it shows that my name is at page number 9. His name was not there in the present seniority. In the cadre of superintendent, I am the senior most to be.
Maybe these are the proceedings of 2012. When he was promoted and when 13. And then why did you not make any representation so many times? Where are those? I'm asking you a simple question. Where is your representation?
I made the details in 2020.
The earliest representation.
Even the appointment of the respondent the Sarabhu court directed the respondent to consider his case as an MR. Instead of doing that, directly they are
Nobody challenged it. You can't come now without.
The PID is only with reference to his seeking his promotion, not with reference to the respondent's legal promotion order. Board not from university guidance that this promotion shows senior. He itself affidavit said that he was illegal shown as senior thing from university to government.
Where has this said?
The affidavit itself is said that. they are seven. It's a further sort of bonus senior to the second responding, the partition of the petition was going to be a maintenance, testimony should have seen same of the petitioner and senior people have submitted their opposition, but same was not taken consideration of the senior.
This is a junior assistant.
The kind of junior assistant. Thereafter, it was one promoted earlier to him as senior assistant, as superintendent, thereafter assistant executive.
So many promotions. You never challenged it. Now at this faggot, after you retire,
My submission is that the promotion is given on a representation by this committee.
maybe that you should have challenged. Now we are after 10 years, you come to the court. Can you come to the court at any point of time? Is it not, no, tell me, sir, is there any person that you have to approach within so much a period before to the court? After 10 years, you come to the court, and that too after retirement, you wake up suddenly.
Because of the immediate promotion, I am getting monitored last night.
Why did you not challenge immediately? Or within reasonable period?
Making on my.
Where is, that's a simple question I have asked. Where is the earliest representation made by you? If you don't have a copy, if there is a reference to it, that is after retirement.
Before return, I have returned.
Then I'll ask them to take their 2020 representation into consideration. Yes? And after,
DID is saying that he should be promoted, not with regard to the quick respondent.
there is nothing here in this. About
Nothing
the,
is with promotion. Alone, last year. దేవస్థానం ద్వారా నన్ను 4వ నెంబర్లో నా సీనియర్ చూపించబడి ఉన్నాను. ప్రభుత్వ ప్రకారంగా డిపార్ట్మెంట్ పొజిషన్ అన్ని అర్హతలు కలిగి ఉంది. సివిల్ కేసు పెండింగ్ లో ఉన్న ఉద్యోగులకు ఉన్నతస్థానం ప్రమోషన్ కల్పిస్తూ ఉత్తర్వులు అన్ని అర్హతలు కలిగి ఉన్నాను. పర్యవేక్షణ నుండి ప్రస్తుత దేవస్థానంలో ఖాళీగా ఉన్న ఏఈ కోర్టులో పదవి కల్పిస్తూ retired now. So considering it now promotion as AE doesn't arise.
he says there was a reference to you for conducting some inquiry into the.
We should produce that if there is any such.
You have made him a party without any.
And
Yeah.
the matter was referred to the report to be directed. And the matter was pending before the conducting inquiry and pending report.
You can't come to the court and then say, okay, now they will file the documents. Let us see. Why should I ask them to file a counter? You have to prima facie satisfy this court that you have a case. You didn't, where is the complaint given by, no, where is the complaint given by you about the genuineness or otherwise of that certificate?
Not only myself, but so many employees who are senior. So many representatives.
Where are the representation? Show me one.
Not.
All right, sir, show me one representation.
Employees that
Don't file any representation. Everything in the air can't be accepted like that.
You are not kindly satisfied. If you certificate produced when this part of that genuine. Why the officer addressed a letter to the Peria University to issue marks and
That this is a certificate produced by him. I do not know what are the certificates that you have filed now, whether they are the certificates filed by him. How did you get them then?
It is based in Facebook and it came in the media also, Myra.
You do not give any details as to when you have raised any objection. What is the objection? You are saying so many people have raised, unless until you show me, satisfy me that there is some prima facie, and that too, that you are affected by it. I will not interfere. It's not a public interest litigation, sir. Yes. So show me how you are affected and when did you raise the objection? You can't raise at any point of time.
The proceedings which my landlord just now that I have filed objection to the senior client.
Where is that objection?
Just now, my sir.
No, you haven't raised any objection. You are asking for promotion. That's it. Please read. After you read now, if you are not able to satisfy me, I'm going to dismiss this petition. I'm telling you. Please read by 58.
It's paragraph of that. Seventh minute of my affidavit.
Hmm.
The purpose of it is provision-
No, up to page 58. This is the representation you are seeking.
Yes.
Consideration.
Promoted as.
Where is it mentioned about the fifth respondent here? Please read.
ఈ దేవస్థానం ద్వారా జాతీయ మరియు ఉత్తర్వులు ప్రభుత్వ ఉత్తర్వులు డిపార్ట్మెంట్ కలిగి ఉన్నాయి. ప్రభుత్వ ఉత్తర్వులు ఉన్నత స్థానంలో కనీస కార్మికులను కాబట్టి మన మై
So where is your objection about the fifth respondent?
I have objected to the seniority.
Where, when? In this, no, in this you are only asking, you are saying there are 4 posts, 2 posts are vacant, consider me, that's it. No, but then why are you making fifth respondent as a party here? And your prayer is this, all this frivolous litigation. No. You can't just make any allegations against anybody and get away with it.
No.
And then, why did you not raise these objections ever? How are you concerned with fifth respondent? Where is it? Where is the seniority list where he has been shown above you? And when did you raise the objection? Nothing. When did you raise any objection about his seniority?
I will protest. I will find the video.
After 2 weeks.
Item number 5, Ramesh Chilla, Chief of Home.
Millard, I am for the Ramechilla Millard. Kindly pass over Millard.
Awesome.
Publish Millard.
All right. At the request of the learning special GP for home to get instructions in the matter, list on Monday,
Selections are not.
finalized now.
Projects order is not final.
List on,
Please, can be decided my senior Millard, pass over Millard.
your senior will not decide, the court will decide, okay?
Yes,
List on 20th.
Item number 6, Govind, Chief of Home.
Yes.
The present petition is by great honorable court to declare the action of the respondent is issuing the removal order. The petition was appointed as a woman after rendering the service for the 15 years. He has been removed from the service membership. And the reason given for the removal is the filing of 3 FIRs against him. And also consequently the FIRs has been connected to the cases because of which the petition has been removed from the service. But before that also the petition has filed a writ petition before this honorable court. And the order copy of the writ petition is there in page number 4553. The operative portion of the order is in page number 53. Sorry, page number 49. Whatever the criminal cases are filed here, it's purely because of the family dispute. There is a dispute among the brothers and the sisters regarding the partition of the interstate agricultural land. Because of which they both filed cases against each other. And accordingly, 3 cases were filed against the petitioner and his wife. And the petitioner also filed 2 more cases against his brother and sister. And since this is purely civil in nature, and based on this, showing this as a reason, the service of the petition has been terminated. And apart from this civil matter, and there are also technical irregularities. That is, whatever the removal order is there, page number 18.
Yes.
The removal order is passed by the superintendent of the police. But as per the Home Guards Act, only the committee is the appropriate authority to pass the removal order. And separated items can direct the removal of the petitioner, and it cannot directly pass the removal order itself. I will submit the judgment. I am relying on the judgment passed by the HIGHCOURT in the batch of petition, where the entire Home Guards batch has been decided. So this judgment is decided in the year 2021. It's a reported judgment.
Yes, where is it?
Appeal is also rejected.
What is the date of appeal?
It is 78/20.
78. Notice before admission. It has to be without counter. It can't be decided. Notice before admission.
Because all are an election duty.
Please stop.
Item number 7, Shivakumar, Chief of Services.
Yes.
Result was astonished about it. And he was accused in a 188 case. Basically, criminal case, the PCR criminal case prior commission, even before that, page 14, you know, the department has framed a charge. 40 it's not harassing your wife, physically and mentally, demanding dowry, highly compensable, and covered the eyes of general public. And it is unbearable to charge your wife, but also report a criminal case. So that's why these for that, your petition already filed a divorce May 35, 2019, he filed a divorce. OS number 157 of 2019. The counter blast also starship hard even before that the department proceeding and the inquiry also conducted by the University of
So criminal case is subsequent to the divorce petition.
No, madam. Yes, madam. Yes, madam. Criminal case is 2019 and she gave a complaint on 22/4/2021.
Yes.
To submit his objection to the inquiry report. Dated 55/10/2020. So the grounds on which the guidelines before the specific mistake doesn't apply here because inquiries.
Page 16 is.
Madam, before that,
Not asking for petition to the inquiry report.
before that, your substance. We should not choose to cross-examine any of the witnesses. Your also can see page 18 here, page 19. Page 19, madam. Charge officer did not choose to cross-examine the witness. Likewise, he has not different, disclosed his difference. When the list LW1 to LW4 in the departmental inquiry as well as the charge sheet one in the same. For a moment, your also can be.
Why did you not choose to?
If I disclose my difference,
No, but then how is that going to help you now?
My lord, this state.
Did you take that objection there before the inquiry officer? I'm not going to do it because it will affect my.
My lord, NDC has thoroughly asked, my lord, but they are all superior officers. They are very fast, my lord. What I am seeking, my lord, let them stay at this stage, my lord, for a period of 3 or 4 months, my lord, the trial will be concluded. Page 34, you also kindly see. List of witnesses. LW1, my lord, Jyoti, and LW2, Hariya, LW3, Manoj Modi, LW4, Venkana. Then you also can see charge sheet. List of witnesses, my lord.
It seems to be a purely personal.
Yeah,
And that too after he filed a divorce petition. Yes. Notice before admission. The very special GP for home. Takes notice on behalf of the respondents and seeks time to find out. The Leonard calls.
4 weeks.
4 weeks.
Item number 8, MR Tagore, Chief of Services.
Monday.
Motions.
Motion.
Item number 9, Chilapati Rao, Chief of Cooperation.
Yes. Not settling all retirement benefits. Huh? Should be should it be listed along with those matters? Why they are not paid?
They are not considering the due element number 224, page number 14. But the current salary, page number 5.
TO 224 is to revise pay scales.
The page number 15, is parallel number 5.
So you want the retirement benefits in terms of GOM post along with WP numbers. Notice for admission and then.
There is an award in central bank. The respondent
So notice I have issued, then I have directed to be listed along with the batch. So let the notices go.
cooperative central bank.
Hmm.
You now got
Yes.
6 respondents.
So notices will go for the court. Yes.
Item number 10, Traffic Law, Chief of Medical Health, TSHIGCOURT Rao.
Yeah, please, Malod.
Yes.
Malod, this is yesterday's matter, Malod. Lordships, Malod, the petition is filed when agreed by the action of respondent number 3, Malod.
Very video.
Yes.
Malod, may I please, Malod? Malod, present that petition is filed, Malod, agreed by the action of respondent number 3, Malod, in not disposing of my representations made on 25/10/2023, Malod. Malod, seeking some briefing time, Malod, for repatriation to my parent cadre. Malod, I have been repatriated to my parent cadre at the Department of Family and Health, Malod. Malod,
On the order dated of GHMC to be implemented. What is this GHMC 2013? Letter dated 18/10/23?
that is the repatriation orders, Malod.
Repatriation order.
Repatriation order. I have made a representation, Malod, seeking briefing time. Malod, my children are studying in the engineering and 12th standard. Malod, I am speaking, Malod, because all of a sudden, Malod,
You are trying to make a director of so and so's party, right?
Yesterday, Bhagyashree Madam started.
Here also, is on reputation with JHMC. He has been repatriated to Director of Public Health.
Respect of 4 persons who are in past.
Yes,
The school individuals have tried to use the expenditure. The last was these schools.
dismiss.
Who others are joined.
He wants this, their representations to be considered. You have made the representation.
510. IA2, Malod. IA2.
IA2 you have filed. To the Commissioner JHMC. Yes, who is appearing for the JHMC? Who is the standing counsel?
Yes.
Printed, huh?
Item number 10.
Pass it over, ask him to come. Acha, he's not here today. All right. We'll post it on Monday. What is the date? The repatriation is to take place, to take effect? 15/10, no? 18/10 is the order.
1810.
With immediate effect and duty level. So I'll direct the commissioner to consider the representation and then thereafter take it.
Yes, sir.
All right, tomorrow.
Motion is full.
All right, in the same list.
I'm obliged.
Number 11, quick one, chief of services.
Yes. Declaring the inaction responsibility. No matter, I had come up earlier also. Page 63. Uh, 65 to make such representations. Did you make representation in your case? Where are those representations? Yes.
Presentations are. But directly, give a specific representation with their particulars and give a directed. The details of attendance to proper channel.
Therefore, I paid the earlier. The same order.
Already they have made Dr. K. Srinivas, Sharma and all that. And it's not signed by anybody. I page number 55 as a translator.
54.
Here they have given, he has given which are the places where he has worked and all that. Representation. It's saying during May 2022 to September, for which a regular remuneration which, all right, let them consider if required, you call for the details. Yes. Similar order as in page number 63. Yes, I'm doing it. 63 and representation stated, representation stated 20. How much time? The earliest 2 weeks. All right, then period of 4 weeks.
4 weeks for
Hmm?
4 weeks for you.
Why? Elections is different and this is different. How is that got to do? 4 weeks.
Item number 12, Naga Meher Baba, chief of services.
May please, Lordship. Appointment of multipurpose health assistant, Lordship. In the Warangal district, Lordship, we given representation on 30/10/23, Lordship, page 22, Lordship. All the 4 covered by Lordship judgment, Lordship, page 94, Lordship.
Yes. Consider the representation. Yes. Similar order as in page number
94, Lordship.
94. Yes.
Item number 13, Surya Sati, chief of social welfare.
The action of the make a notice in RC statement. Your brothers got responded to it. Presenting the fourth respondent. Yeah, related the. Without giving any
Daily wage individuals.
Yes, Your Honor. He has been appointed in the year 10/11/1999 as senior assistant. Your Honor.
99.
Yes, Your Honor. And also the similar repetition also pending.
Where is that appointment letter? Where is the appointment letter?
Your Honor. He's 29 years.
Page number 29.
Page number 29, followed by 30 years.
Yes.
10/11/1999, he got appointed.
I tried to get in fact, but it's from the base of it, but.
This is on 10th. It's not necessary to attend ITD office.
This is transition notice and undersigned authority as notice creation of nuisance and gaming the same of ITDA by the two daily individuals who are working in ITDA office and decided.
Page 14.
This order does not.
Without any
notice.
Yes. What is the admission? TSHC services.
And number 14, prepare services.
I starting as super. She was instituted in ACP case and trapped in ACP case, and she was convicted in 2007. Thereafter, she was dismissed from services in 2017. On the file of the criminal appeal 317 of 2007.
Now you have been acquitted.
She was acquitted. And while she was, the case was pending, she was superannuated in 2018, June 2018. So she made representation 5123, 72, 23, 25, 93 for all constitutional benefits, including pension and all.
So your representations have to be considered.
Considered.
So you want a direction to consider and pass orders on your phone. Where is your representation?
Lord, page number 16 to 1921. Last representation.
Yes. Yes. In this situation, the petitioner is challenging the
election period anyway, it will not be happening.
Why? Election, only the politicians will be going around asking for votes. Others are supposed to work, right? Are you involved in the election duty? That you can't do this duty?
Maybe because another day partial of the election, because it's cheated.
She has been acquitted in the year 2022. For more than a year, you're sitting over the representations. Yes.
Item number 15, Rajasekhar Rao, Chief of Municipal Administration, Narendra Reddy.
Married daughter.
Rejected him for appointment of.
The possible is not paid. Well,
Acha, for Mr. Narendra Reddy's presence.
Respondent number 1. And subsequent to that, the board has also issued a rejection letter.
No, married daughter, only because she is a married daughter, you have rejected her case.
There are 3 daughters. 3 daughters. She has suppressed the fact that even in the affidavit saying that there are 3 daughters. And it's legal. It is not stated in the.
There are 2 daughters only, 3. There are no
3 daughters.
It's a divorced daughter and the daughter.
Yes.
Okay.
Here they are married.
Hmm.
He also married. The time of mother was died. Author of the petitioner was died long back. And the spouse has not chosen the dependents. Only thing is, mother was died. They are claiming that they are the entitled for that. And no objection certificate are not even produced for that. And as per their page 21, customer kindly this they are saying that they were submitted, but it is not in the record. And customer kindly see the include.
What have they said they have submitted?
It requires counter. Required to file a counter.
No, only on the ground that she is a married daughter who obtained divorce after. See, if I can understand if there are any all counter claims by other daughters. There are no. May.
But they were not challenging that. Proceeding has been issued by the board on 21/6/2023.
Where is that?
They are not filed.
Oh, the board also has rejected.
Yes.
What they have challenged is memo dated 30/5/23.
Entries are issued by the government, principal secretary. Subsequently, that board has rejected their case.
All right, file your counter.
If I found. Notice time.
Notice book for admission, list after 4 weeks for counter.
Item number 16, Venkatachal, Chief of Services.
Yes. Extraordinary leave. Yes, yes. Yes.
Page 14.
Page 14.
And with respect to the first item, your request for permit is contest in the assembly election for the year 23 from Elena constituency from based on the report, the executive council. This pursuant to meeting held on 20th October 23 and the executive council has reserved as under. Reserved the site permit 16 of the response machine in class conductors. The request for a response to allow her to contest the assembly election for the year 23 from the 11th. We not agree to any of the above resolution and also conduct rules to exceed and inform that your request to permit you contest assembly elections for the year 23. He is not agreed. A WhatsApp this rule 16 is not ended. The other was around my yesterday argument because others are concerned. They are able to contact the debate. That is concerned IDC, not present.
Page number 26. This was given by the registrar on 22/9/2050. Yes, 26.
Yes.
Because you participated in this elections for Warangal.
Yes, yes, he was given permission, there is no doubt.
Permission only independent health, this is not hands.
Here also, she also want to contest as independent.
There are two, hence your
Hmm.
hence your request cannot be agreed to. However, the university can permit you to contest in the election, Lok Sabha and independent candidate in ensuring the by-election to the school. Subject to approval of the Hindu council and the any rules and so on. But in this case, subsequently, the executive council of the university is the apex body, rejected their case in that case, subsequently.
Then he came to the High Court.
Rejection.
Rejection, then he came to the High Court.
Yes.
High Court has permitted him.
The court also is not so specific.
Then-
In this case, the other case, the approval of the EC only it is rejected. EC rejected it initially as per rules. But I thought this date the rule is in force. They are not under the rule also. They cannot rely on the letters of the registrar and other candidates.
There is a rule yesterday, I think you filed.
I filed a copy, rule 16. Yes, they filed. Page 18. Page 18. Rule 16. No university employee shall, while being on duty, take active part in politics which includes holding of office elective or otherwise in any political party, standing for election to the state legislature or the parliament, or to take part in any other election on a party. Provided that the university teacher may contest elections from the graduates or teachers' constituency by taking the leave on loss of pay for the entire period of his election campaign, and also if he is elected for the entire period for which he is elected. For MSc elections, he can enter to contest now, as per this rule. For the assembly or parliamentary concerns, he is not entered in fact. And either the state, this rule is intact. They are not under rule also. But Intumar is concerned with the matter that is the only Intumar.
Yes. Notice for admission. Telangana. Huh? Is it today?
Item number 17, Hanumantarao, Chief of Services.
From 28/11/2013. Why from that date? What is the significance of that date? So you have retired now. After retirement, you have come. What were you doing when you were in service?
We have filed an petition in the year 2014.
Hmm.
When petition directed to by way of representation. Yeah. The same. Therefore, representation has been rejected. Voting that there is continuation of that. According to you and left.
All right, notice shaft 4 weeks for counter.
Item number 18, Ramsubarao, Chief of Services.
So sanctioning arrears of pay of duty and 91 to 2005. Counting of seniority from that time onwards. Also fixing pay notional. Huh? Anyway, okay. So notice it's after 4 weeks for counter. Interim order cannot be passed in this. It has to be after counter. Why? What is there? After he comes also it will be the same. What is the interim order he is asking? To consider the representations, stated one, so for sanctioning arrears of pay. All right, pass out.
Item number 19, Rajshekar, Chief of Services.
Questioning the rejection on 7/10/2020.
Notice just after 4 weeks. You're still in service?
Number 20, Ramgopal, Chief of Services.
Regarding the beginning of the teachers will transfer the procedure to a fight.
Yes.
The Lordship stipulates some time and then make alternative arrangement movies of 3 days. The Lordship thereafter they will elect. Are partly allowed here and here. Purpose of transfer is repeated. It cannot go repeating the same thing. The Lordship stipulates some time.
So here, how much time you want?
You are already submitted. I know about this. The Lordship, where I filed a record statement yesterday, it came further. I think my Lord's section and state that where the transfers are being installed, promotions are being installed, where I got included. We also they took time before the elections, can virtual transfer, that's what happened. Because we go by the moral mood of the court, Lord, you cannot say more than that. So, there, Lord, my hands are tied. And you issue notification of now, like when the process is not yet commenced, transfers per state, commercial state, more improvement. When this is going to be happening? The spouse category, very difficult for them. After long of 10 years, 8 years, they have been believed as per the NCLT points. Lords to stipulate some time, take out them alternate government within 2 weeks of period. Thereafter, we don't get them leave. Straight away, I'm not asking the Lords to grant in 3 weeks or 4 weeks time because today is 9th. By the December 9th, the elections will be completed. Immediately after election, they will be. 4 weeks. That's what I'm saying. 4 weeks parallel only.
You have made the representation.
You have been making the unions also making representation. Now, at least the petitioners who have come before your Lordship, this board may be considered for relief. All others not interested. At least the people who are This case is present.
Yes. You want this as an interim model or I can dispose of it? Dispose of the requisition. Notice before admission. When it GP for services, one takes notice of behalf of the response. Then it also for the petition submitted that despite of the transfer orders being issued on sports grounds, the petitioners are not being relieved of their duties. Therefore, the petitioners are submitted. So the Learned Council for the Learned GP for services, one is directed to get instructions. One similar company, in similar cases was directed to get instructions. And it is submitted to various other reasons that are state granted in promotions and also in the vacancies, large number of vacancies, due to non-recruitment of teachers. If they are not able to find alternate teachers to be posted on the basis and therefore these petitioners not being relieved. However, having regard to the fact that the respondents have conducted the counseling and have also passed the functional orders, they ought to be relieved. The respondents are therefore directed to make alternate arrangements within a period of 6 weeks from today and thereafter relieve the petitioners from their services to join in the case. I said 6 weeks because election duty, everything will be there. They want to.
The order may be given. The transfer order may be
That's
given.
what I said. 6 weeks from today, they should be relieved and so that you can go and join your basic course.
What can dispose the record of?
But I wanted to, you wanted it to be.
What will dispose the record?
These are actions that impression is disposed of. Notice before the election is said. Yes.
Number 21, Srikant, cancel registration.
Number తప్పించింది రాయడం తప్పు 3057 752 572 రాస్తారు తప్పు ప్రశాంత్
Tomorrow, the motion. Yes, no. That actually different matter has to come. The name is wrong. The requisition number also. Non-service matter. There is another matter we should. Tomorrow in the motion.
Item number 22, Ramesh, TQS services.
You are challenging the punishment order. Punishment order, no? What is the date of the punishment order? 21/1/2020.
When he was working as senior accountant, they issued a charge.
See, you have challenged the punishment order.
Punishment is all underwent 2 punishments.
Okay.
When orders dated for the same allegation, 5 the punishment of withholding of 1 implement. Subsequently, after 4 years, government revised the order and 10% cutting pension was imposed in 2008. Now, after 15 years, we are not stating anything which is got earlier punishment. They are issued a show-cause notice for revision of punishment, revising punishment. But the petitioner submitted an explanation stating that already is underwent 2 punishment for the same set of allegation. But once again, we are issuing show-cause notice is illegal. Instead of saying anything, they are imposed another punishment, page 28, 5% cutting pension. After 16 years of his retirement, he is already undergoing punishment of 15% cutting pension.
So in addition to that, now again another 5%.
That time, same issue, in fact, the person involved in the same issue was let off with the punishment without anything. Initially, was imposed 10% cutting pension. Now, it's was let off without any punishment. That is 75 years more than that.
Yes. What is the date of this order? 21/1. It's already.
Ajit for labor, Ganesh.
Yes.
Other matter has 10,752.
Then I think.
Labor.
Adi children.
30,752. These two revisions.
Adi.
Yes.
These two are to be listed together.
Yes.
Okay.
These matters, in your aspect, kindly see. Since 20 years, the workers are working in the company. And I have listed how they are being used, the workers have been used, I have listed the chronological events with that. In fact, the account number 5, management, is not at all, they are providing anything to the employees and they are extracting the work and they are squeezing the blood of the employees, the employees. And there is no facility, there are no precautionary equipments and no PF, no accident compensations, everything, no balance sheet of the company. Entire thing, they are, since 20 years, the skilled workers are being paid only 20,000 rupees to the maximum. No workmen's compensation, no minimum wages act.
How is this differential maintenance?
That I submitted because the alternative remedy is there, but
You have to go before the trial.
The thing is, I have only asked them, wherever my principles of your auditor is well aware that principles of natural resources have not been followed by the company at all since beginning. And as well as
the company is a private organization.
Yes, but
So
I have given a representation to the Labour Commissioner, particularly the Labour Commissioner, Assistant Labour Commissioner. So I have the union so many times have gone to the Labour Commissioner's office, but for the reasons best known to them, they have not passed any orders of the representations. And the workers have threatened them whenever they ask for anything. The Houseman kindly see the photographs. Some of the employees' limbs have been cut, and one of the employees has died in the furnace, and no compensation has been given. And there are bonded laborers, they have 18 years, 16 years, 15 years, workers have been used, and the management is not giving PF, EPF, entire thing they are not ESI, and accident reports are also not being given to them so as to claim compensation. That is my record submission before the Supreme Court.
This will appeal for labor.
Yes. As per this section, we had 12(3) of the ID Act 1947 signed for the additional and prepaid class. Boards below 31/10/2023 below.
What is that?
31/10/2023.
What is that?
3 years agreement at 18/5/2021 to 31/10/2000.
Agreement for what?
For the agreement. There is understanding between the.
All right, no, he has made representations to the Labour Commissioner.
Yes.
The union has made.
Yes.
About certain irregularities or whatever is the injustice being caused to them.
Yes.
So what is the action plan? You are supposed to.
Yes.
That is also there. Item number 23 is that.
Same matters.
21 and 23, both are same. Get instructions as to why they have not at least taken some cognizance of those complaints and take some action. That's what.
And I have listed your Lordship, can you see page number 25 onwards, the detailed representation of the employees, their grievances before the Labour Commission. And their management is using them as a bonded labour since 20 years.
The company, against the company, the writ may not be maintained.
Yes,
but as far as the Labour Commissioner is
Yes.
concerned, whether he has acted in accordance with
They are
law,
not acting upon.
not taking any action, whether they are required to take any action, let
Yes,
him get.
yes. Let them file counter to that, so that the Lordship may decide this.
No. About the fourth respondent, we'll see whether writ is maintainable against him at all. At the request of the learned GP for Labour to get instruction.
The both matters are posted.
Both matters on Tuesday in motion.
Mobilization.
Tuesday in urgent motion.
Number 24, Mallikarjun.
Hmm?
On medical ground, he terminated from service. As per the circular,
Who is the respondent? Singareni College.
As per circular figure, is the right to person appointment with any legal of the
Yes.
second employee. The respondent and the second son who is the first son is a mental disorder. Hence, I requested the respondent can take details of my second son. But taking any details about my son below and simply the state domestic reasons in case to the driving the issue. Then my second son is eligible for the contract appointment.
Where is your representation?
They're not taking the appointment.
They're not taking. You are removed from this one on 8/4/23.
Yes. The page number consider.
Okay. You can inspection. At the request of the Learning Standing Council.
27-29 same.
29 అయిపోయింది కదా closed as infectious.
Item number 30, Srinivasa Madhya, Chief for School Education.
Allowed.
No, no further orders, it's very close.
Item number 31, Jagan.
Rejected.
Already rejected, ma. All right, next week.
33 also.
33 is considered an allowed.
Allowed.
33.
So 31 next week,
33 also.
33 allowed. So what is there? He has produced a copy. Their appeal has been allowed. Petitioner's appeal. So closed. No further orders needed. Closed. Yes.
Item 32, Rangopal.
Rejected. Closed with liberty.
Item number 34, Pimpri Raj.
Same level.
Next week.
Next week.
Item number 35, Mohan Gaur, Chief for School Education.
Rejected.
Rejected. Closed with liberty.
Item number 37, Sudhakar Reddy and Neeraj Arya, Chief for General Administration.
Yes. Rejected. Closed with liberty.
Item number 38, Ram Gopal Rao, Chief for School Education.
Stay. Rejected. Liberty. Closed with liberty.
Item number 39, Ram Gopal Rao, Chief for School Education.
Stay.
Item number 40, Sudhakar Reddy and Neeraj Arya, Chief for General Administration, Chief for School Education.
Stay. Closed with liberty.
Item number 41, Sudhir, Chief for Services, Srinivasa Madhya.
Have you filed an amendment?
Amendment is transferred from that portal where is already produced with the 270. 279 has been withdrawn. And it is something like one of the particular first respondent taking over the jurisdiction of the lordships. And then saying that I will decide. When 279 is withdrawn, automatically 275 comes into force. Therefore, what he could not do directly, he is doing it indirectly by issuing an order saying that it is in process. The lordships rightly notice.
Now IF5 is before this court. It is amendment of layer.
And there is also followed IF4 and 5. Suspension.
We are approaching the government. Having approached the government, his petition not made up with my most sufficient. I will file my counter.
You want to file a counter to the IA?
Yes.
I just say this for
He is according to
one
the.
second. One of the lordships will not be with respect to deal with this matter in the manner which is supposed to be, because what person lordships have seen, he has issued a GO. The very next day he issues another GO without reason and right. The lordships have interfered. Division bench affirmed it. One second. One second.
Everybody has got a right to say, isn't it?
Same story, same case will be same story only.
When you speak also, the court hears.
It will be the same story.
Everybody gets an
How
audience.
can I have another story in this story?
All right.
So,
Yes.
after that, bro, from 26/9, he did not implement. The same jet speed he shown to admit the second respondent on the same day of 279. But when we went below and then asked, he did not do so. On the ground, that 2 vacant stays are filed, one by the government and one by the R2. But I checked up with the law, whatever available sources. Here, because vacant stay is filed, it is not as if they cannot implement, they should not implement. The understanding seems to be vacant stay is filed, so deal is decided, we won't implement. When 279 is not in existence, but the R2 has no business to stay there, we file a contempt also. The lordships wanted to initiate show moto also, and then that's one of the directed for appearance. And then
they came and mentioned and sought to ignore it for complaints. Now, after complaints also brought so much of resistance in shown brought by 2.63 and all that brought something to hold on instead of sinking. For 2.63, I brought a judgment of the Kohima bench of Lohati, where it was stated that it is only directory but not mandatory. Therefore, the lordships have directed the matter to be posted tomorrow because my friend wants to get a judgment showing that 2.63 is mandatory. On that day, 386 is produced. All this will show that there is a fight between two parties for 279. But he has the audacity to draw the jurisdiction of the lordships and say that it has become infractious, and I will decide where to be posted. When my prayer is not only to set aside 279, to implement 275 also. Right that has been created is now sought to be taken away and then said to say about it is infraction. But the conduct of the first respondent will also have to see. There has to be an end because finally the lordships have the authority to decide with matters. The bureaucrat dealing in this fashion, but it doesn't augur well. And as an officer of the court, I have a responsibility to bring it lordships' time notice. That this particular gentleman cannot take things in this shape, taking advantage of the situation. And lordships large heart cannot be accepted. Lordships will not tolerate this. And now situation is very appreciated. I was not given posting for some time, I was given. Now, despite 3 judges, significated 2 judges in the division bench, holding that I am entitled to continue there. Prima facie. Still I am entitled. And that man is still continuing there. If this is 1 second, sir, after I finish, you can say. Once the rule of law has to be, if the rule of law has to prevail, otherwise it's anarchy. These courts, view and orders have been thrown into the dustbin, will not entertain that. Anybody, whoever it be. Now, I'm seeking, that's why you have to see the conduct of the party. Because 226 is not just 2 plus 2 is equal to 4. Lordships will see the equities also. Now, I filed amendment because 386 GO is to some extent it is my favor where 279 is withdrawn. Does it not amount to interfering with the justice delivery system to use up the power of your lordships to look into the matter? Therefore, I also sought for a suspension of 386, which is nothing but again interfering with 279 is set aside on a ground of that it has been done with urgency and arbitrarily. That portion for ability not be carried.
I am aware of that.
Yes.
We have gone through it yesterday or day before. Yes.
Therefore, I am seeking suspension of that.
He has been working in Hyderabad, he has been studying. He is trying to create an impression to the he is in my country. He did not have very much.
So both of you are working in Hyderabad
Yes,
only.
he is
No
not
problem.
He says that his name, my client is name, is not a fact. Therefore, that may not be, he cannot create an instance because his company is name. Second submission is that in process of 386, he approached the government. Having approached the government, he cannot seek suspension of the order, and I file my counter to the.
He has filed a petition before the government against 386.
Yes, no, I approached the government.
He approached the government in what way?
For posting order, for reporting and for posting order. Because he approached the government for posting order, in compliance of 386, his petition not made, I will find my counter to that.
You can. Yes.
But we also heard that we are seeking time because without amending the pleadings, we are not declaring settled law in course of time. At this time, what will carry out?
May just say this, my friend saying that I was not in here. They did not mention in the counters.
I have mentioned, I have mentioned where he is working. I have mentioned my counter, Canada to which is working.
Where? Where is he working? Where is he working?
In Bangalore, not working. He's Hyderabad. In the earlier coaching, he has been working. He has get it from my counter of previous.
Earlier work, For 8 months, I was waiting for
No,
posting.
he is not making it, I have stated so.
And see the 275 and 279,
Not that
he
he-
says that I was waiting for posting.
No, it is wrong wording, he has been working, he has been drawing, sir, he has been working, I have stated so.
Waiting period also he crossed money, sir.
I have stated so, my lord.
Where have you said?
A specific case is from December till present posting, I was not given any posting. By promotion. While he was enjoying 3 posting.
It is not about posting, whether he is working or not is the issue.
Correct. That there is no mention either in the out that I was working.
No, who is working where, how much period, all that is not the without.
He said that he is not in the-
See, that has to be taken into consideration by the government. That will be done. Yes. Where have you said?
Within GO itself says not waiting for posting.
No, he is working, my lord. It's
Where is he
very
working?
loose, that also.
On that, yes. The in IA 4 and IA 5. The learned CP for services, 6925 counter. And the learned study posted for the
He was not.
how can we continue once this order is?
But let them say, Lord, that is not continuing since the day of your lordship's order till now.
Somebody else was told, all these not without any.
1 second, sir.
Somebody else was told.
Who is that other somebody else? No, who is that somebody else? Let them say who is that somebody else.
No, he is continuing.
Both of you were directed to report for posting orders. So what have you given any posting orders to them?
Because now.
Then who is working at Medship Malkajgiri? Have you given additional charge to somebody? You can't leave it
I
off.
have been relieved from that place. I've been relieved and reported.
No, you are the government. You are the government.
Shall be relieved. My client has been relieved.
You are for the government.
You lost-
So have you issued any posting orders to anybody? If not, if the person you have not given, please. Please, I would expect some decorum here. No, please.
Some decency, my lord.
No further arguments here. Once you have suspended, you have withdrawn that letter, the client of Mr. Srinivas Rao cannot continue there. Right? Then you can't leave that place also. That place also can't be left like that because it's a, I think.
I'm not saying that, my lord.
So you must have given some additional charge to somebody there. How can that place be left like that? So without issuing orders, how can you manage? How are you managing?
In this, one post, my lord, additional charge was given to somebody else.
Who?
Watching one lady, Karim Nagar.
She has been given charge of which place?
Full additional charge.
Of?
Of Lord DAG Karim Nagar.
So where Mr.
We are talking about Malkajgiri.
Nature Malkajgiri.
Not regarding anybody posted. Pass it over and let that.
All right, pass over.
Paragraph 9 of my affidavit, I stated he has been working, actual competitor has stated.
Did him work?
Yes, no, he has been working.
Pass over.
As district registrar, MBNA.
Who is now in charge? What have you done after this withdrawal? What action have you taken? You have not issued posting orders to anybody. Then what alternate arrangement you have done?
Not election for.
So then who is, busy with election work? Government servants can't take that stand that we are busy with election work, so we will not do our work. He is not a politician. He is a.
Working.
Then
Who is not working?
R2 is not working. Then who is working there? Registration office can't be without a registrar.
It's not registration.
This is a transfer registration.
DIG is not there.
DIG.
There are grade 1 deputy
So
inspector.
who is looking after that work? Yes, pass over.
Yes.
Yes.
Number 42, Ramesh, Bharat Prakash.
What inquiry report? What is the issue here?
Because the petitioner was working as the assistant Kakati University as a telephone assistant. The university allegations are that while it is repeating the telephone bills, he increased the embezzlement of the bills and all. So therefore, they found, they conducted the departmental inquiry and found guilty.
Termination of order.
Termination for the post of telephone assistant.
So you have challenged it on what grounds?
Yes, the point of can also file a criminal case against him, where we got acquitted. Therefore, he approached the found guilty because of the acquittal in the criminal case. There, the termination need to be reviewed. This honorable court passed the direction the same lines, saying that it has to be reviewed.
That is an interim direction.
Let's see, page number 17.
IA1 is ordered. What is IA1?
Yes, that is the amendment by
amendment of player.
Yes.
Okay. Then
and in the main repetition, that's material 17 to 19.
So there was no representation on behalf of the respondents of the justification. So it was directly listed under the caption for order. So you have brought what? The inquiry report is with you. What is that you're saying? What is that? Inquiry report.
Now that now whether the inquiry conducted.
So the directive was given in the earlier round of litigation, petition to reconsider. So now they have passed the order again, confirming the rejection, termination. So inquiry report was not part of the earlier documents filed. Take
the extraction of the gist of the report was already included in all the repetition as well as this new.
What is the problem in taking it?
It's not necessary.
Not necessary is a different thing, but what is the problem in taking it?
But
why should you object?
Last occasion, learns immediate order for the inquiry. So therefore,
it is that.
But my point is the gist of the inquiry report already.
All right, you don't want time on behalf because it's all right.
Let's come to the
Why?
Because I have just now we have received the copy report. We'll go through the plan. Takes almost half day.
Let's
go on the matters.
Why? Whatever are the findings, you take me to the relevant portion.
Embezzlement of funds. That you not more than finance.
And next week we'll take up.
Has to be disproved.
See, if somebody says it's not prepared, then let's at least next week. Next Wednesday.
It's not prepared. It's already been there in that one, but it's not in that bulk funding. But it is the gist of it. No, although there are 100 or 200 pages. But
Next week, next Tuesday.
Under the same caption.
We come under the same caption. No need of for orders.
Yes.
We can remove that from orders and post it on next week. Next Tuesday. Yes.
Number 43. Allah Baksh, Super Natch, Umali.
Where is my lady? Yes. There's no representation on behalf of the respondents.
No, I'm saying for process for them. Only for them.
And
Umali is for
there's no representation on behalf of the respondent.
Item number 44, enjoy, keep your attention.
May I please, your lordships?
Yes, Mr. Gaur. Yes.
Your lordship, the petitioner seeking for a compassionate appointment on the death of his mother, your lordship, in the year 2008, your lordships. And she made an application before the second respondent, wide application on 13/4/2009, within the 1 year as per the GO, your lordships. And she has been running from pillar to post as on this day. And they have not even implemented the GO or my application. They have not taken any action against my application.
So your application is still pending consideration.
Yes, your lordships.
When did your mother die?
My mother died in 2008, your lordship, 19/4/2008.
So whether you have made the application within the time prescribed 1 year?
Yes, your lordship. Within the 1 year, your lordship, I made my application on 13/4/2009.
Where is your application?
Application, your lordship, is at page number 11, your lordship.
Page number 11. Okay. And the latest representation?
The latest representation is, yes, your lordship.
33, page number
29/5/2023, 34 page.
All right, and direct the respondents to consider and pass orders.
As an interim order, your lordship, may I kindly.
By interim order, it can be decided, yes.
Yes, your lordship, within the time frame, your lordship may decide.
Yes, in this situation, the petitioner. By tomorrow.
Deeply obliged.
Yes.
Item number 45, Vedal Chitralinga, keep your services, Ram Gopal Rao.
Yes, made the application for the position of action date. It was notification issued by the state on 3/9/2022.
Last time, Mr. Ram Gopal Rao appeared and he wanted to file a counter. To get instructions. Yes, where is he?
Followed by the,
Why are you being treated as non-local?
They say that it's not, though no, nothing is given to me in written, they say that you're not, you violated clause 7 of the, GOMS number 128.
Now, what is your education? Where did you study?
He studied
Details.
classes 1 to 6 in Andhra, but thereafter he studied in Telangana. He has pursued his engineering also in Telangana.
So they are considering only 1 to 7, that's it.
No,
Not the minimum qualifications.
Where I've extracted the class 7. But it says local candidate, a candidate for direct which post shall be regarded as local standard in relation to the local area. In cases, in cases where a minimum education qualification has been prescribed for recruitment to the post, if he has studied in an education institution or education institutions in such local area for a period of not less than 4 consecutive academic years, ending with the academic year in which he appeared, or as the case may be first.
I am aware of all this. I have passed the orders.
Yes.
But yes.
The only difference is in that case where my laws have passed the orders, I have granted the unsuccessful. He could not get the exam, but here he has secured a rank of 7th. I placed that also. Taking a similar relief.
Where is the order?
Passing orders on page 79. They filed an application, but at that point it was required that he did not secure any, he did not get the recovery was closed. That also is based on page 87. The relevant portion of my law started from page 85.
Pass over.
Yes.
Item numbers 46, 47, 48. Venkatramreddy, Chief of Education Command Area.
Last time you did it. That time you said, Lord, that they sent it for the draft is already prepared. These are the matters.
Next week.
Same under the adjourned motion.
Next week. Next what is
Item number 49, Karnataka, Chief of Services.
same list. In this matter also need to find count.
Yeah, please, Lord.
I want time to find count. Count is not found. Next, how much time? 2 weeks.
Serious condition, 2 PPs are implemented in law. Several times they are taking inter.
Pensionary benefits.
Yes. The order, Supreme Court order, they are not supposed to file. Page number 84. 84 of the law.
Oh, criminal appeal was allowed when?
Pending law.
Still pending.
EC is acquitted.
TC has been acquitted. It's the state which has preferred the appeal.
Even though appeal.
No, state has preferred the appeal.
No stay law.
No, state has preferred the appeal.
Yes.
There's no state. Then notice was ordered on 25/4/23. As a final chance.
Next official.
2 weeks time is back.
Page number 103 Supreme Court order, even appeal, 90% of the release is legal law. Please see that above. Page number 103 Supreme Court order.
2 weeks.
2 weeks adjourned motion list.
Same list. Okay.
Yes, adjourned motion list.
Item number 50, Ramakrishna, Chief of Services.
Seeking for considering my representation, no, Lordship, I can say page 12. Moreover, Lordship earlier asked about the reference, we have filed memo, my lord, to that extent. They are in the reference also. Hello, Lordship, I see the reference below. The attention of district medical and health officer command is invited to the reference work cited and is requested to take necessary action in the representation of D. Ramakrishna, field officer, so and so. As per rules in force, the competent authority to the post of the field assistant. And then consider my representation.
Where is their representation?
Page 12.
Yes, what is the problem in considering the representation?
I saw for today's meeting, sir. And told me not, even course of the day,
Pass over. Pass.
Is there on this thing?
Like tomorrow. What is there in a day? Tomorrow.
Same.
Yes.
Adjournment.
Tomorrow in the same.
Item 51, Education Saina, Chief of Services.
Regularize the suspension period and consider his name for promotion. Notice was not ordered. Yes, you were supposed to get instructions in this matter.
Yes, my lord, this Nagapur was pleased to allow one petition, Lord. 3 months time is given for us to like observation in Lord as expected. Even the time has not been asked for. This is equal for me.
Not in this case. That was in another case. Here, he's come here saying that his juniors are being considered for promotion. 30 page number.
Page 30.
Yes. What is the date of this order? 20th September 2023. 3 months time is there.
A report has been forwarded to the CCHM, Lord. On page 32.
Yes.
Considering its interest, Lord. Page 34 is the operating portion.
All right, next week, I'll post it next week, get instructed. At the request of the letter chief, this next week.
Item number 52, Filtrira, Chief of Services.
Next week, same.
Geotagging for the pictures were getting faster in the most cases. Where it turned the cities have been answered initially, later it put on the path transferred to the some other places and differences with the others. Format and also ask for instruction.
Yes.
Justifying the field where the within 50 kilometers radius, the geotagging must be there, which is existed in the previous application.
I have not received any instruction. Huh? No, whether geotagging is, what about the facility of geotagging? I don't understand this geotagging.
Geotagging is installed right to assist the school assistant. Subsequent promotion is start for the STD with the husband. And if it all right off near the place of the husband, it is the regulations will not where the DOs are making that the spouse must opt the spouse within the mandal, within the village, within the school, within the village or border to the mandal. Sometimes what will happen will not after later part after the husband of who is having STD as an STD or wife is having STD, she also have to go for the transfer. And if at all she go far away, the problem will arise. To eradicate that will not previous transfer way made it as mandatory 50 kilometers radius within the spouse working. If that comes, cannot facility will be there for the spouse.
Yeah, now get instruction. No, this is a facility you had given earlier in the earlier counseling. So what is the problem in giving it now? That only it was posted today. Yes. Next week. There is no urgency as it is. What is urgency now?
Emergency.
Yes. In the daily list. It's in the daily list.
Item number 53, Mangala, Chief of Services.
For the same?
For the presentation given to the Secretary of the matter is pertaining to the
For allocation to mention Malkar.
yes, ma'am.
Under the SC category.
SC category. SC generally
Special
is
category.
accepted, but additionally the SC mentioned
There is no acknowledgement of this, but you post by post.
by post.
Yes. Yes, come. This is the representation.
Yes, within. Within.
The commissioner is seeking a direction. Hmm? You are challenging the ID. ID order. You are appearing for the unofficial response. Have you filed a counter?
No,
Not necessary. No need. You are appearing for which respondent? There are two people here. The employee and the company. What about the third respondent? Contractor.
He's a contractor.
No. What about the notice has been served on him? Third respondent. No, because I think if I remember right, your contention was that he was not working with you, he was working under the contractor.
He's not working with which he is
Working under the contractor.
and it is submitted.
So, contractor is also necessary party, he has to be here.
Officer is very
You're not-
trial court advocate notice ఇచ్చున్నాము.
So, no, but since he has made a party, he has to be heard. Learned counsel is permitted to issue personal notice to respond number 2. Only 2 picture. 3 can give a
పర్సనల్ నోటీస్ ట్రయల్ కోర్ట్ అడ్వకేట్ ఇచ్చున్నాము 88 రోజున మనమే మేడం 88 ఎస్కేసీ గారు మాత్రం 2 ఇచ్చారు మేడం. మనం అందరికీ ఏమని చెప్పి చెప్పాం మేడం. Notice on behalf of the council appearing for the respondents before the trial court 88 ఇచ్చినాం మేడం. ఆర్డర్ కాపీ సరిపోతా అయింది.
Yes, you have not filed proof of service on third respondent. You were permitted to serve notice on behalf of the council appearing for the respondents before the road court. No, first initially when notice was given, only respond number 2, you were permitted to take out notice and respond number 2. Subsequently, when it came before me, I have given a direction to serve the notice on the respondents, the council appearing for the respondents in the lower court. Have to take out notice to each other. I'll not hear it in peace, please. They can take out notice, it can be taken out.
What is mandatory that has to be done. 67 will be, I have permitted to take months.
No, he says, I think the service between the service between whether you are working with the petitioner or with the third respondent is also one of the issue. So let it be served with the respondent. Let the notice be served. That also will consider after service of notice. Third respondent.
Minimum you are asked to see 2,500 rupees the last dance. The lady person for 20 years, 2,500 you will get it. That is a bad point. If you ever got a complete country, you got to find it.
You consider all that if it is as well, no, you will be getting it, everything arrears and all that we can direct. Don't worry about it. Yes. At the request of the Learned Counsel for the petitioner to file proof of service of notice on the respondent number 3 or the counsel appearing for the respondent number 3 in the lower court. List after 10 days. On 20th, I am posting. 20th. Huh?
2 weeks.
Or 22nd. Interim order granted, shall extend it till then. It has to be extended, sir. Once it is granted.
Both powers with the extent of dispensation section 17 is very limited. Because if the shell is used. So last dance salary has to be paid whatever the reason it is.
Let me see next time. Yes.
Number 55, Sheikh Samir, Chief of Services.
May I please your ladyship?
Yes.
appear for the petitioner here in my lords.
Yes.
My lords, this is a matter where my lords petitioner has been terminated as District Child Protection Officer Gopalpalli based on an alleged inquiry conducted on the section.
Has the counter been filed here?
My lords, in this matter, my lords, for the past 6 occasions it is coming for the counter, my lords.
There is
Even
an
though
interim order in your favor anyway.
no, my lords, the interim order is in fact, my lords, it is detrimental because, my lords, they are not filing a counter. My lords, I will take 1 minute of your lordship's time, my lords, if I am unable to.
We'll vacate the interim order then. If it
My
is
lords,
detrimental to you.
no, my lords, I will, my lords, for a second, if I am unable to satisfy your lordships within the first glance, my lords, I will not insist, my lords. It deserves a modification, my lords.
You want a modification of the interim order.
My lords, may once peruse through page number 21 to 25 of the IA2, my lords. I will not insist further.
1 minute, Mr. It is services 5. Print the name of GP for services 5 and this tomorrow.
Oblige.
Suhasini, GP for endowments.
May petition. But I filed a vacancy petition.
Yes.
By submitting the petition working as an adjunct correspondent.
Yes, sir. Made a representation for what? Time scale.
That will fix the time scale. And I'm relying upon the judgment asked by the order to take it direct. They don't come down state or legislative. But even though the order was not considered, the other side town council has filed a vacate petition. My request is lordship may kindly take some time to get. So on that day, final argument.
What was the direction of this court? Interim direction was
to consider representation.
To regularize the services, extend the pay scales. That is a final order, basically. Your lordship can see interim order.
Where is the interim order?
Interim
Yes, that's
direction.
right. Interim direction to pay the time scale. That's it. Where is the case of? Where is the direction to for utilization?
I spread for you. Lordship can see the order, my lord. I'm sorry.
Interim order has.
I spread for.
And what is the as where in the request?
Your lordship can see page 37, my lord. The High Court may please to direct the respondent to regularize services as Archaka in the third respondent temple and grant him time scale instead of consolidated pay as was given to the other sales. That is the interim prayer granted by your lordship.
We'll take it up next week then. Come prepared next week. Next Wednesday.
Oblige.
What is the point of interim order? And they filed the stay vacate. And yes.
Item number 5738, Mohammed Abdul Rashid, GP for services, Praveen Reddy.
Suddenly, item 56, interim order grant valuation stand extended and thus. Yes.
Then, finally, matter will be taken. Lordship posted for today.
Yes.
The only legal appointment we have, which is in second side.
Who is appearing for the respondents?
Here.
Praveen Reddy. Is not here.
No,
He is here.
I'm appearing.
Actually, you are appearing for
I'm
him.
appearing for.
Petitioner counsel is not there. Last time due to paucity of time, the matter could not be taken.
Last time I said it's going to work 10 minutes. Lordship posted today to be heard finally.
One more opportunity next week. We'll take it next week. No representation. No representation of the petitioner. This next week. We'll see if he doesn't come by next week, then I'll post it for dismissal and then discuss it. Yes.
Item number 59, we will come on.
Next Wednesday. Next week and take. It's a Monday. Next Monday week. Next Tuesday. This is a adjourned motion. So it will come in the next week, next Tuesday.
Next Tuesday. Yes.
Or Wednesday, you can put it in next week, Wednesday.
Item number 59, P. Ramana, Chief of Services.
It's a stay vacation file. So inquiry has been stopped. The request of the Lieutenant Counsel for the petitioner to file a rejoinder in the counter filed to the respondents just after 2 weeks. Next one also say. Section 59 interim order grant resolution status. Yes, 60 also same. 60 is different. Interim order is there here also. The counters are yet to be, the Rennet GP seeks further time to file counter. Just after how much time? 3 weeks. Interim order granted and there should stand extended in there.
Item number 61, P. Teja, Chief of Services.
Counter is fine. Yes, when did you file? 6th November. Okay. At the request of the Rennet Counsel for the petition to file the rejoinder to the council for the respondent. Just after how much time? Yes, 2 weeks. Just after 2 weeks. Yes.
Item number 62, Linda, Mahendra.
Yes. Counter is filed. Stay vacant is there. Yes.
The petitioner who are appointed ministers describing in daily wages during the year 89, 90, 91. And the regional engineering college, which was in existence, and subsequently regional engineering college came to be converted to the National Institute of Technology during the year 2000. The services of the petitioners are being continued, they are now working. During the year 2002 also they filed an application for the regularization of the.
So when were they appointed, engaged?
So 89 and on daily wages. Can be have a look at the.
Okay.
Now, during the year 89 and 89 onwards, 89, 90, 91, 90.
Okay.
They have completed more than 3 decades. It is not in dispute, it is a matter of record, their services are being continued even after it is a conversion into National Institute of Technology, which is governed by the NITSER Act.
What is that act?
It's National Institute of Technology Services
Rules.
That is now the act came into be enacted. Now with regard to regulatory merit, with regard to the internal arrangement and creation of board of governors with regard to the regulate all the merit affairs, internal activities and regulating. The power of board of governors. Now, with regard to take the plans and the decision policy with regard to this. And while matters to the merit, now these are the merit, the matter related to merit, the issues of continuation with regard to whether it is being described as a merit regular or ad hoc. Ad hoc is not unknown to it has become a common merit with regard to the phenomena insofar as the governmental services and its governmental agencies category. So these are all the expected method is being continued, which the export in several judgments that is the melody notified thing. That is the Karnataka versus Sumadevi case. The fate of the melody, all the explanatory method where they are the victims in the hands of melody this departmental cost of the department is concerned, it is not unknown. And the court has considered with regard to the para 53, where your lordship has also been coming to the notice. Now, with regard to the way of the circumstances with the government and the Supreme Court has explained with regard to the ad hoc cases with regard to that. This, the Supreme Court has considered the constitutional rights, constitutional applications, constitutional consequences with regard to the continuation of ad hocism has been well explained. Now, that is the well-represented action that the government has seen, and its agents have been directed to take frame one-time measure with regard to the make and all these regular or permanent. Now, with regard to this measure, now the managing company board of governors has taken the decision to fill up the vacancies of all the existing vacancies. The decision has taken the policy decision to fill up all the existing teaching force and non-teaching force. The petitioner hearing comes within the well parameters not teaching force. They have taken the policy decision to fill up the force by giving the open advertisement with regard to the external candidate, and with regard to the in-service candidate is concerned, the internal notification. Now that you not handle. The policy decision which has been taken by the board of governors of the institute concerned to regulate and take the decision to fill up these vacancies, existing vacancies. So, your lordship is well aware. So far as the filling of the vacancies, whatever the condition precedent, there must be existing available vacancies. Therefore, they have taken into consideration a conscious policy decision has been taken by the managing director of the committee, that is the authority. So, with regard to the vacancies, accordingly, the internal circulation has been given, inviting the application of our in-service candidate,
So where is that? Where is that?
Well, that is concerned page 83. Page 83.
Page 83. Yes. It is 7-23.
Okay. This is underdated 7-2020.
Yes.
The applications are invited among the eligible daily wage workers of the institute to fill up the vacant positions of the post office attendant and the lab attendant in the institute as per the following. This is the importance of the decision. A follow-up action has been taken. This should be an invitation with regards to notice.
Okay.
Well, and now this is concerned, out of all the persons have not been. You know, there are out of 95 candidates now still available working daily wage workers. You will not say just now there. Out of 95 workers is concerned, they want to fill up as per the merit of the recruitment rules is concerned. What is the qualification and with regard by giving the age relaxation is concerned, that is the thing. So, having invited application among the scrutiny, the screening committee has been constituted with regard to this. After they have shortlisted these candidates out of 100 candidates, that is 95 candidates. Only 23 persons have been made shortlisted because they possess the qualification under the recruitment rules and also following the rules of the ring. Accordingly, a mock test has also been conducted. And the list of successful candidates has been recommended by the screening committee. Accordingly, appointment orders have been issued. And by conferring, whereas the status of HIGHCOURT, we are now calling with regard to the different nomenclature's name. We are calling Arahasism is concerned, daily wages, outsourcing, contract, whatever they are giving name. It is like give the name to the job, and kill it. Like expanding to the by the government in the instrumental is in order of this in motion now. They themselves with their own agenda. As per the power conferred under the statute. And once it has been exercised, and now after conducting the test where the appointment order, working orders have been issued, we have been minute of the working against the conferring of the nature, the nature of.
All right, so you have participated in the examination and accordingly you have been appointed, selected.
Screening committee.
Selected. Where is this order?
Now the appointment order will not pay kindly.
Yes, where is that?
Now the will not pay kindly look at the orders are concerned. Whereas page 91 onwards, now the because individual orders have been given.
Okay.
Individual orders have been given with regard to these. Now the page 80, whereas a list has been published at page 85. Page 85.
Okay.
These are 23 candidates who have been in the short list melody is concerned and also has been given the appointment order on the basis of screening committee made a recommendation. Then you will also kindly look at the appointment order each individual. You are first page.
Yes, sir. Now
86.
Yes.
The 86 onwards, now this appointment order, daring report.
One you can read it.
One only. Now the after this, by Yadgiri was according to the post of office attendance in pay level 1 and the so-and-so reference was reported for duties on 14/6/2023, who by letter reference accordingly. The Yadgiri is hereby appointed as office attendant in the schools under the unreserved category subject to the conditions stipulated in the offer. In the official of the rupees 18,000 pay, the allowances being made by the account of students is now governed by the National Pension Scheme and subscription shall part from the fees. So once you know this office order, now the appointment orders conditions will not just out of the red with regard to that.
So June 21st June 2023, you were given appointment.
We have been working.
Now they have given you cancellation.
This has been cancelled. Now those orders have been cancelled by the order which has been chosen challenge.
What is the reason for given for
cancellation? What they say is, we have not now the call for the included open competition, but the external candidates have not been now the call for, along with the internal with regard to these notification is concerned. Very little meaning of internal notification of the resolution process, the decision and policy decision taken by now the Board of Governors, which has been conferred by the statute. There is no power of melon now once it has been exercised and it has been exhausted, it has become sufficient. There is no question of melon now tinkering with the powers in the absence of any review of the melon decision of constitution. That there must be a legislative competence. The statute must prescribe any decision which is required to be melon reviewed. Your Lordship cannot in every adjudication or insofar as the decision which has been taken place, even the recent decision of court is concerned, once a conscious decision has been taken by the same authority, cannot to go back and saying that the rule of principles of constructive estoppel. Now the rule of estoppel comes in the way, they can't be able to go back when they have taken conscious decision and subject of selection and appointment of nature of appointment, status of appointment cannot be cancelled or changing service conditions, depriving and also reducing the amount to millet without issuing any due process of law. That is principles of national justice is also violated. Lordship knows the courts have been repeatedly holding. Now, millet, it is any order altering millet with regard to which involves millet against such as the civil consequences Now, the such kind of minute of any decision is not only contrary to the element principles and foundations of national justice. Therefore, by any stretch of imagination, even apart from that, the options of merit is power. You not even the option is now they are at the age of merit 56 and some of them 49. At this age, the courts to merit the decision you notify saying. Now, with regard to the not only merit Uma Devi's case and the Mangal from the other case, which I paid the judgment in the reply of the week. I don't think you will with regard to, I am required to read all the judgment in the reply of the week. With regard to that, and the Miller to proper assistance to the Honorable Court, I taken also Miller trains Miller to give the synopsis. Now, with regard to this, if you not permit me,
yes,
I will
can give this.
because I don't want to waste of time because of these laws matter which has already been considered. When the court, the series of judgment, it is not a case one, it is an internal notification, external notification. Very literal meaning. It is not a case where the resolution or the policy decision taken. If any decision is contrary to the policy, I will be accepting it is that you can't take the blame. You can't take away even assuming it is a lapses or anything. Even if it is not a conscious decision, then you can't take up the advantage of your own lapses, thereby condemning with regard to the persons who are innocent with regard to the power. Now that you not make angry, it is not only violation of human rights, Article 21. And this policy is concerned, it is not unusual or uncommon. The government and the not being well aware. Now, 1994, even the state acts proceeding, only after 1994. They were in melody in employment. Is well considered melody with regard to that. Every employment is not necessarily a force, but every force is necessarily to be employment under the management. We have admittedly measured under the employment of the year and the benefits measured with regard to that. And no law can be made measured. The marks of events in the course of measured the fact which we are in the midst of time. Now, constitutional development, a constitutional right, a constitutional development measured with regard to that. So you can't find fault with when during the period when you exploit the situation. Administrative exigencies concerned, you have funded when there was no competing claim and you yourself adopted from the 30 years back. What was there now? You can't find fault. Your appointment itself is wrong. Your very existence insofar as it is concerned, exploiting and using for all these years. Now it allowed on the amount of the
all right, let's hear them. Yes. What is the reason for cancellation?
But before the company cancellation issue, because the petitioners have mixed up the appointments with regularly. The repeated assertion that they have been working for 30 years. I need to give the background of the engagement with the petitioner in these two. They are continuing. Because the repeated they have been exploited is being made to punish for. Injustice was done to them. I will not read all the relevant paragraphs, but I'll only take your logic to the relevant pages and then explain what has been. And as stated by my friend, petitioners, some of them, because according to them, they are working since 15 years to 30 years. My friend ignored that 15 years, but in his own
production centers they have been working on. Similar to some of those who are above TDS, they were engaged on projects which work for 3 months, 6 months, 1 year. By the individual departments. There is no role for the institute for engaging them on those projects. They were engaged, and once the engagement of the project, with the project coming to conclusion, the engagement ceases. But having cultivated the officials of various departments, when once a project comes to an end, they get into another project with the assistance of another person, where another project is there. This is not an engagement by the institute. The projects are given by various agencies outside. Funds are given by them, and from out of the funds received for the projects, they can submit.
You have stated in the counter, sir?
Yes, sir. I have stated.
Para number.
Page 5.
Yes.
The continuation of para 4 is in page 5. Unnumbered paragraph 2nd. The instant repetition is filed by 23 daily rated workers who were engaged by the erstwhile regional engineering project in various projects.
Yes.
Consequent upon the conversion of regional engineering college, earlier when it was regional engineering college, it was under the control of both the central government and state government. It was ratio. But in 2003, it was taken over by the central government and renamed as the National Institute of Technology. All the regional engineering colleges all over the country were renamed as the National Institute of Technology. Now, 31 NITs are there all over India. But these employees, these daily rated workers, I call them employees, these daily rated workers, apprehending that once the NITs are formed, they will be relieved from the daily wage employer. They approach these officers and filed several petitions. In page 7, they are mentioned. 9th line.
Yes. Para 6, you have given the details.
It is para 6. This honorable court granted in the interim order. But to continue it on the same terms. And subsequently, the final order was passed on 4/10/2007, a common order. That is at page 7.
Yes.
Bottom.
Yes.
I will not read the entire thing, but I will just briefly state what was stated. The letter text said that their services may be regularized. The respondents last 5 lines. The respondents are directed to consider regularization of the services of the petitioners if sanctioned posts are available, and if necessary by seeking permission from the Ministry of Human Resource Development. Government of India is regarded as appropriate orders. This judgment is at page 40. I will only take your to page 47, the last paragraph, which I have read just now. It is at page 47.
Yes.
Page 47.
Last paragraph. Last paragraph.
In the above circumstances, the respondents are directed to consider regularization of the services of petitioner. This is important. If sanctioned posts are available, and if necessary, by seeking permission from the Ministry of Human Resource Development of India. This is a conditional order. But since regularization is not possible, because non-teaching employees and teaching faculty ratio has to be maintained at 1:1.1 as it tells. But since 393 daily wage employees are there, but, as against the teaching staff, it was exceeding
much farther.
What is the ratio? 1:1?
1:1.1.
1:1.1. One teaching to 1.1.
Teaching and not teaching staff. The matter was placed before the Board of Governors. And Board of Governors advised the director to address the Government of India, Ministry of Human Resources Development, as it then was. Now it is called Ministry of Education, but it was the Ministry of Human Resources Development then. But MHRD refused to grant permission. It said strictly 1:1 ratio. 1:1 ratio. Since it is not possible because excess staff is working, they were terminated. Termination order is at page 40. Page 40.
Petitioners were not amongst them.
They are among.
They are among.
Yes, yes. The first petitioner is at serial number 33.
Okay.
But before coming to this, I take your lordship to the contempt petition also.
So after the termination order, they have filed a contempt.
This termination order was issued, but since they raised hue and cry and create a lot of disturbance, that the termination orders were kept in abeyance. That is at page 50. They were deferred. Contempt petition was filed. That is at page 51. The order is in the picture.
Yes.
Para 9 is relevant. Page 54.
Yes.
The directions of this course as extracted are conditional as subject to availability of sanction posts as well as permission of the event office. Even assuming that the sanction posts are available, will the permission of the MHRD for taking the recognition essential, even as per the directions as above. There is no material produced to show that MHRD has in fact granted permission and is the respondent entity which is not complying with the order. Apart from that, the proceedings of the MHRD referred to that on both occasions, MHRD insisted to maintain faculty and non-faculty ratio, and without approval of the creation of post was not possible. The matter, however, appears to be pending with the MHRD. As such, as on today, it cannot be said that there is any willful disobedience on the part of the in complying with this court. As noted above, the non-compliance or disobedience of the respondent, disobedience by the respondent directly, would arise provided MHRD grants permission for regularization to the petitioners and still the respondent directly does not comply. Since that is not the case for the petitioners, I am of the view that there is no willful disobedience on the part of the is made out by the petitioners. The petitioners have stated in the petition and the reply also that the order passed by the learned single judge in the batch of cases common judgment has become final. That is a conditional order. That conditional order would not be complied because MHRD did not permit. And the contempt cases were also dismissed. And it is an admitted fact that the termination orders were not challenged, except raising hue and cry in the institute and creating a lot of disturbance and interference and labor unrest in the institute. These termination orders were not challenged. And all the petitioners are in the termination orders.
So these termination orders were not
challenged.
Not challenged. Yes.
And they have been continued Initially because of the interim order. And subsequently, after the termination because of the fuel price raised by the government, there is no requirement of the petitioners to work in the organization as daily wage employees. They are working as daily wage employees ever since. And several writ petitions were filed. Some of them joined with others, and several writ petitions are filed. And one such writ petition came before Mr. Sanjay. My friend referred to state of Karnataka was Madevi case. In that case, the judge dismissed the writ petition saying that there is no evidence to show that they were appointed, no appointment orders are filed. There is no evidence to show that they are appointed as against the sanctioned post. Even assuming that they may be working for 10 years or more. But there is no evidence that they have been appointed as against the sanctioned post. There are other conditions in the judgment of the Honorable Supreme Court in Uma Devi case, which my friend filed in full, and I filed the office memorandum letter, which extracts the relevant points that the
Correctly, page 56.
Even in the reply affidavit, when my friend has filed copies of the judgment.
All right, so you have said that you have to, it's only a one-time measure and cannot be cancelled.
Yes, they could not be. Your Lordship may kindly take the reply affidavit. Just take the page 21.
We did not go into all that because now it is not,
I only take your.
the regularization is not under this one now.
Yes.
Appointment or cancellation of the appointment orders is other thing.
Lines only, not the entire judgment.
Oh, page
Page
21.
21.
Yes.
One last 3 lines. Equality of opportunity is the hallmark, and the Constitution has provided also for affirmative action to ensure that unequals are not treated. Thus, any public employment has to be in terms of the constitutional scheme, since it is relevant for the purpose of this activity. There are 2 last 2 lines. 3 lines. Filling up of those vacancies cannot be done in a haphazard manner or based on patronage or other conditions. Regular appointment must be approved. Then your Lordship may go over to page 22, last line. In the last 2 lines. If rules have to be made under Article 309 of the Constitution, then the government can make appointment only in accordance with the rules. State is likely to be a model. Then Lordship may go over to page 20, page 34. 27. The court was referring to the earlier judgment in Umarani's versus last 6 lines. This court also held that regularization is not and cannot be a mode of recruitment by any state within the meaning of Article 12 of the Constitution of India, and any body or authority governed by a statutory act or the rules framed thereunder. Regularization furthermore cannot give permanence to an employee whose services are ad hoc in nature. It was also held that the fact that some person had been working for a long time would not mean that they had acquired the right for recognition. That these words are clearly applicable. Then page 35. That's the last 7 lines.
a regular appointment, Your Worship, to a post under the state or union cannot be made without issuing advertisement in the prescribed manner, which may in some cases include inviting applications from the employment exchange where eligible candidates get their names. Any regular appointment made on a post under the state or union without issuing advertisement as in present case, inviting applications from eligible candidates and without holding a proper selection where all eligible candidates get a fair chance violate the guarantee enshrined under Article 16 of the Constitution. Then you also have to go to the next case, that is page 46 and 47. This state of Karnataka was a table case. Page 46, your Worship.
Yes.
Paragraph 5.
So these are the general principles.
The employee concerned should have worked for 10 years duly sanctioned. The petitioners were not working in duly sanctioned. Without the benefit of protection of the interim order of any court, they were working in, on the basis of the interim orders of this government. In other words, the state government or its instrumentality should have employed the employee and continued him in service voluntarily and continuously for more than 10 years. They were terminated and they were forced to be retained. It's not voluntary on the part of the state. Then page 47, 5.2. The appointment of such employee should not be illegal, even if irregular. Where the appointments are not made or continued against sanctioned posts, or where the persons appointed do not possess the prescribed minimum qualification, the appointment will be considered to be illegal. I wanted Your Worship to attention to this word illegal. But where the person employed possesses the prescribed qualification for working against sanctioned posts, but had been selected without undergoing the process of legal competition selection, such appointments are considered to be illegal. Then, page 67, Your Worship. As a circular last year, 5 minutes. It may be worthwhile to note that in Umadevi's case, schools were dealing with appointments made without following any rational procedure over various union and states. So that Umadevi is clearly not applicable.
Yes.
Then, so as the restriction which my friend referred to, that is at page 60.
60 of the
Wicket
counter. Yes.
Before starting, I just briefly state what transpired on the page. But after sanction, most of the available. The recruitment notification. The petitioners have challenged that recruitment. The recruitment notification was challenged. It came before this on before. And they did ask me, why don't you accommodate? I said the rules do not permit direct regularization which they are asking for. And in another petition filed by friend he clearly said that the petitioners do not have the qualification, therefore they will not apply. And in the case of the petition filed here, the judge asked me, I said they are not prepared to apply for in response to the advertisement. They simply want regularization, which is impermissible. The learned judge said asked the petition counsel to ask the petitioner to apply for the courses. They asked me whether the time is available. I said date is over, but if the court directs that we will extend the dates and receive the application. Telangana directly permit to apply and their applications for received. And all of them are petitioners. Petitioners, they applied for the post. I also said to the court that the institute for the daily wage employees who are petitioners here was prepared to give coaching to enable them to appear for the written test. And for preparing for the interview also training will be given. And age relaxation for the number of years which they worked, that is also being given in terms of the resolution of the Board of Governors. So in spite of these relaxations, they are not applying. They are directly not to apply. They applied, all the petitioners applied, and they were unsuccessful. They did not get through the written test. So they have been asking for regularization all the while. Then, so not to make any the
who passed the resolution.
We are coming to the end. Why do you object now?
No, I'm
Yes.
saying.
Yes.
He was speak tonight, but I did not speak a single word. This is the habit of interrupting and it was very
Sir, please. Yes.
He has wasted the time of the court by repeatedly.
Now, let's not go into all that, sir. Let's not lose the string. Come on, let's go ahead.
So, the decision of the Board of Governors, which my friend referred to, I will take your options to the request system. Third line onwards.
Yes.
First line onwards. It is humbly submitted that the minutes of 58 meeting by circulation were circulated to the POG members on 16/1/2020. And none of the members have made any changes or corrections to the minutes. Objections. The minutes one of the members has clearly said that it has to be according to the recruitment rule. This statement is not correct. As noted from the website of the institute, the BOG in its 59th meeting held on 24th has confirmed the above decision. Dates your Rashmi kindly note. As noted from the website of the institute, BOG in its 59th meeting held on dated 24/2/2023 has confirmed the above decision / minutes of the 59th meeting of the BOG and action taken before on the decisions of the BOG. The minutes of the 59th meeting held on 24/2/2023 and the action taken before were also approved by the 60th meeting of the BOG held on 18/5/2023. 24/2/2023 minutes of 59th meeting held were approved. Approval is on 24/2/2023.
Yes.
18/5/2023. Confirmation is 24/2/2023. The vacancy circular you are to find is issued on 7/2/2020, much before. Even before the confirmation by the 59th board meeting and approval by 60th board meeting. The vacancy circular, which is at page 83.
So without getting the approval itself, we have issued the notification circular.
Yes.
Not for the application. Yes.
83. This was issued on 7/2/2023.
Yes.
Third, the earlier submissions is in respect of the repeated assertions in the petition and the reply affidavit about regularization, which is the background was necessary, therefore I had to state. Now, I will come to the powers of the court.
But if the approval was not given, report. The 60th meeting BOG held on 18/5/2023. You are not disputing any of these dates.
No.
So then approval was not given by on 18/5/2023.
Approval was given on 18/5.
For
Confirmation on 24/2. Approval on 18/5.
18/5.
But vacancy circular was issued on 7.
On 7/2.
Even before confirmation and approval.
Okay. Now after that only you have given the appointment letters.
It was almost preempting. It was almost preempting it. And now, whether the board has power to issue approve appointments through internal circular. Your Lordship, kindly see page 26 of my counterpart. Is the National Institute of Technology, Science, Education and Research Act 2007. 26. 26(3).
No, you have counted.
Page 25 of my application.
Page 25 is rule position.
25, 24 and 25. 26 also. This is the National Institute of Technology, Science, Education and Research Act 2007. The relevant sections are 5.
Okay.
Page 26, statutes how made. Page 21, section 26.
26.
Statutes how made. 26(3). Every new statute or addition to the statutes or any amendment of the previous statutes shall require previous approval of the visitor, who may grant assent or withhold assent or remit it to the board for consideration. Your visitor is the honorable president. The board has no power to deviate from the recruitment rules or the statutes. The policy decisions are made by the council. Council functions are in section 32 of page 26. But
yes,
it shall be the general duty of the council to coordinate the activities of the institutes. Without prejudice to the provisions of subject council shall perform the following functions, namely, your Lordship may ignore A, B. To lay down policy regarding cadres, method of recruitment, and conditions of service of employees, institution of scholarship, tuition, levies, other account. The relevant parties to lay down policy regarding cadres, methods of recruitment, and conditions of that. So whether open advertisement has to be issued or the internal circular has to be issued, it's a policy decision that has to be made by the council.
No.
Then, your Lordship may kindly see recruitment rules were this statute 23(1) is at page 30. Page 30, statute 23, appointments.
yes.
23(1). The posts at the institute shall be filled by advertisement on all India basis. This is important. There is no other method of recruitment except an advertisement on all India basis. Then Page 31. (2311). The post is to be filled by advertisement. The registrar shall advertise the terms and conditions of the post. Then 16 at the bottom line. All appointment made at the institute shall be reported to the board at its next meeting. This is important. Thus, the appointments which are made were reported to the board at its 62nd board meeting. As required under statute number 2316. They were reported to the board at its 62nd meeting. Extract of the 62nd Board of Governors meeting is at page 39.
Yes.
The BOG has reviewed the recruitment rule. As the appointment of 23 office lab attendants was made through internal circulation without giving equal opportunity for outsiders through an override. The institute is directed to cancel these 23 appointments. The BOG further directed the institute to initiate recruitment of personnel against these posts through an override. The board is also advised to consult the application to the appropriate candidates. This is as required under statute number 2367, substatute 16. They were reported to the board as decided to cancel the appointment. Then,
yes.
Then issue was raised in the reply affidavit that board is only competent to appoint. Has no power to review its own decision and cancel the appointment. So, Dr. Can you see section 16 of general charter?
Yes. Yes.
Power to appoint to include power to suspend our business, where by any central act or regulation, a power to make any appointment is conferred, then unless a different intention appears, the authority having for the time being power to make the appointment shall also have power to suspend our business or any person appointed, whether by itself or by any other authority, necessary for that power.
Yes.
In that regard, yes. Reading para 3, which is quite elaborate. I just read the gist of it in the below the head note. The power of appointment conferred upon the custodian under section 10(2)(b) of 1950 Act confers by implication for the custodian the power to suspend or dismiss any person appointed as manager. Thus, the management of a person with regard to the business.
So it's okay. It's power of
Yes.
government includes power to.
So since in the requirement, it is categorically board has no power to review its decision. It only has not the power to appoint. So for that purpose, the Living Trust Act section 16 is there. Then I've already read to your October asked by this court with regard to regularization and the termination of the petitioner.
So the cancellation is because you have not issued an open advertisement.
Yes.
And therefore you could not have appointed them. That's the only reason for cancellation of the appointment.
Yes.
Right, that's it. What else?
What's my guidance? See page 10 of the report.
Yes.
Page 18.
Yes.
Second line, and none of the members have made any changes, corrections to the minutes. In page 14, para 10, my counterpoint. What one of the Code of Governance members has observed, I have page 14 of my counterpoint, para 10.
Oh. Yes.
Sorry.
So with this, your argument will be ending. Let me continue after that. You are for the petitioner or the respondent?
Respondent.
Have you informed the other side?
I did not have filed.
You can take a duplicate bundle. We'll see about the adjournment and then when it reaches. You are for the petitioner.
Respondent. Petition.
9 of the expression.
Page 9.
Yes. Sorry, para 9 of the expression.
Para 9. Yes.
In order to comply with the directions of the economy, there are some directions. As I said, the common order passed in 2007 was complied. And just since MHRD did not permit, their engagement was terminated. There is no question of any consideration or complying with the directions of 2007, which was complied by terminating. Then, para 13. It is amply submitted that while the petitioners have rendered their sincere and blemishless service to the satisfaction of their heads of the department, controlling officers, and not received any communication to the effect that their work and conduct was efficient, but they just worked for 3 months. But performance appraisals within that short period of time will not be done.
So they are working from period.
They are saying about
That's after this appointment. Okay.
Then I have already showed you the TSHC Act and the statutes for which the appointments can be made only to the advertisement on RTI basis. I will not repeat that. And take your lordship to judgments which I cited. First judgment, let us repeat versus page 2, para 2, your lordship. Respondent case was appointed on daily basis. Indisputable was not made in terms of statutory duties, as in the present case. Then your lordship may go over to page 5, para 13. Question which does arises for consideration would be: is there any distinction between irregular and illegal appointment? The distinction between the two terms is apparent. In the event the appointment is made in total disregard of the constitutional scheme, as also recruitment rule framed by the employer, which is stayed within the meaning of Article 12 of the Constitution. The recruitment would be an illegal one. Third, in the present case, the appointments are made contrary to the recruitment rules and the TSHC Act. Therefore, they are illegal. Then, para 13 last 3 lines, just above para.
Yes.
Judged by the standards laid down by this court in the appointments of the respondents are illegal. They do not thus have any legal right to continue in service.
Okay.
Then, next judgment is nothing of Teachers Association. Page 15, para 27.
Okay.
It is now well settled in our Sabha.
Yes, yes.
Principle of law that any appointment made in violation of the constitutional scheme of equality, as enumerated under Article 14 of the Constitution of India, as also in violation of the provisions of the Act and subordinate legislation framed thereunder, would be wholly illegal and without jurisdiction. It has been so held by the constitutional bench of this court, incidentally, State of Karnataka and others versus Mahadevi and others. Then you are still move to page 22, third judgment commission. Page 22, paragraph. The appellate is a state within the meaning of Article 12 of the Constitution of India. It was therefore obligated to undertake this selection process in terms of the Constitution under Articles 13 and 16 of the Constitution of India, as was done by the NIT, which is the state within the meaning of Article 12.
Yes.
The rush may go to page 24, 15 and 14. constitutional scheme in regards to public employment as enumerated in our explicit. Any appointment made by a state officially being the party or the constitution must be subject to the constitutional scheme. In making appointments, the state is obligated to comply with the same as also the requirements, if any. Neither the appellant nor the state to grant any exemption in regard to compliance of the statutory requirements. Then in the next paragraph, the fourth line last. It is now well settled in principle of law that any appointment made in violation of the statute or the constitution would be illegal. Then you also may go to both case notes. Let us start with the law here. Judgment of this page that paragraph 53.
Yes.
It is well settled that an order cannot be quashed or set aside if it revives an illegality or an illegal order. In this case, if the cancellation orders are set aside, they will revive the illegal orders of appointment. In that context, a reference may be made to the Venkateshwar versus Government of BP and State of Corruption versus Council. If the impugned order is set aside on the ground that that it contravenes some provision of law, and also on the ground that petitioner was not given opportunity to meet the allegations in the Shoka notice, and a direction is issued to first respondent to grant legal recognition to the petitioner. It would enable unrecognized institution to handle in-country and in-country adoption, which is quite contrary to parliamentary enactments as well as binding parliamentary guidelines. In this context, I was repeatedly saying that here there are no allegations or inquiry against the petitioners. The appointment orders which are issued are illegal. They were
Cancelled.
Cancelled. And for that purpose, in this judgment, as this court said, no notice is necessary. And next case, Abdul Sattar's case, page 41, paragraph 4.
These are contentions of the petitioner council. Para 4 is contentions of the petitioner council.
That was extracted and then in para 6 and 6, 7.
Let's come to the finding of the court.
Yes. Para 8. It is obvious that any interference by this court setting aside the order of review would amount to resurrecting that part in the award, which is evidently an illegal one. It is settled law that no writ to be issued quashing an illegal order, give effect to or reviving another illegal order. Same G. Venkateshwar case. Then 6th line onwards, the order review by the random has not resulted in failure of justice. The Court of Equity, when exercising its equitable jurisdiction and article, must so act as to prevent perpetration of a legal fraud, and the courts are obliged to do justice by promotion of good faith as far as it lies within their control. Then you must go over to page 55, paragraph 11. But almost page 50 or so, 42 paragraph. Even assuming for the sake of argument, the petitioner's contention that the victims know of the first point of the money, no relief can be granted to the petitioner because if the said memo is set aside, it will revive the illegal and void order of the district petitioner. And that if the setting aside of an order or article 2 in the 6th would have the effect of reviving another order, which is also contrary to law, this court should not grant any relief to the petitioner with the petitioner. Then the case number page 55, paragraph 11, last 3 lines. However, the court declared to grant any relief petition as it would amount to giving effect with an illegal award granting interest on solution. With 56 paragraph 12 last 6 lines. Therefore, though this court has no manner of doubt to hold that the LAO has no power to review the award except to a limited extent of correcting mathematical and clerical errors, this court is not inclined to accept petition as it would amount to rendering an illegal award legal. Jurisdiction under Article 2 of the Constitution is intended to ensure rule of law and not resurrect illegal awards. Then read the page 59, para 14.
Yes.
First 3 lines you know can wait to discuss with the position of the petitioner. Then the 4th line of though the order passed with respondent number 4 is against principle laid down in Judgment of Case. In the opinion of this court, if the order passed by the revenue officer is set aside, it amounts to revival of illegality and the same is not sufficient. But my solution is if the cancellation order was set aside, they will revive the appointment orders which are expressly illegal because they were not made in accordance with it. Then there are there is one more statement in public employment is not confined to the employment extent to public notification in newspapers also should be given to give wide publicity so that it will give opportunity to all the people to join that.
Yes.
Parties are same, but judgment is rendered twice, 1987 to 1999.
Yes. Will you briefly, sir?
And so far as the open trust, so far as with regard to the contingency of person where now he is the referring, which was not in existence, because he is saying the relevance and the concern why now I am bringing to a lot of duty. Here is a case where the decision policy are taken with regard to the merit, with regard to the particular situation. To fill up the vacancies concerned in respect of the working merit employed and also merit with regard to the internal merit notification and also adopting merit external notification. So lots of whenever external notification requires merit of the inviting the person. Insofar as the open competition is concerned. Now, insofar as service law jurisprudence is concerned, the internal notification and external notification, literal meaning and taking the policy decision to give effect, and when it is the merit of binding the executability of a decision, which has been carried out with regard to the contingency is concerned, the two cadre. One is teaching cadre and another is not teaching cadre. Same execution of particular instrument. Now that is a policy decision. You accept with regard to there is no action against the cancellation of the appointment. If all the appointments made other than teaching force and non-teaching force.
So there was an internal notification for teachers.
Internal notification issued and external notification.
For teachers. Teaching.
It is not teacher. One is non-teaching staff is concerned decision taken is to fill up in respect of the working in service candidate who are working on an ad-hoc basis on the work.
Yes.
Daily rate wages.
Who possess the qualification.
Now, with regard to they said pass a resolution with regard to the requisite qualification as required merit under the recruitment rule. The entire decision taken with regard to the reference and the taking into consideration my conscious decision with regard to the languidity of millet, now with regard to the working employees, and with regard to that, they have taken internal millet notification and external notification. So they call it is a binding and executability decision which they have taken and implemented. And if logic relevancy is concerned, it is not their case. Now it is we have not questioned the qualification. It is not their case. We do not satisfy the requirement as prescribed under the policy decision to fill up the existing vacancies concerned. And now with regard to the cancellation order is concerned, you will have to be well aware. The statute which prescribes the particular millet exercises the power with regard to the fill up the particular contingency. That has been exhausted. It has become functions official. And also it has been implemented. They have been given the appointment order after due process of selection, recommended by screening committee. And also the posting orders have been issued. It has been thus implemented, which has become functions of issue. They are entitled to the very orders condition is they are entitled to millet till attain the age of millet retirement is concerned, superannuation. Therefore, it is very clear the appointment order which confers a status of regular appointment. Your Lordship is well aware, the regularization denotes and also connotes with regard to the status of regular or permanency insofar as the force. And now I fail to understand with all my comment insofar as the service law is concerned. Now we know the employment. Now the employment and also post. Let us understand millet. Now every employment insofar as the establishment is concerned need not necessarily be a post. A post which millet connotes now the employment of the establishment. Once you are accepting one way, no other way they are saying confusing that now they are appointed, now the question of regularization does not arise. One way of millet is breathing millet saying something. Well, the decision on that is a matter of fact is appearing for the management establishment. Now it cannot be spelled out from his mouth, saying that there were services were already terminated. You know, the concept of merger, no, where it was not given effect, keeping an order and now in their pocket. Now the contending with regard to defeat and frustrate the claims of the petitioner, invented novel method of argument where now the advocate's role is to see and ensure a proper assistance insofar as before the honorable court to assist in proper manner to millet for a proper adjudication. That is the role and adversity of the millet with regard to the every day, now the day to day. This kind of defiance and the millet, strange millet of the argument, disowning and binding decision made by them, saying that all are which are non-existing facts, etc., is being relied upon is non-relevant. Therefore, in the millet, law laid down by the millet, the Supreme Court, which has been para 53. You will not make any the 53 and judgment letter. Justice Millet, Amchadar taken the millet analysis. Now I have given that I don't want to collect the rest of the I have given the synopsis. And also under the judgment. You will not make kindly have kept only one of the judgment which I could not employ the principles of natural justice is a fundamental. That is the millet well settled principle of law. All the proceedings wide of an issue, now that is one ground. And another ground is concerned when the decision which has been taken, one now policy decision, and you can't say and argue the partly it would be valid and partly it is not valid, has been deprecated by adopting appropriate and reprobate process of millet this understanding. It is not millet informed. It is nothing but challenging the civilization millet of the attitude. Now, therefore, millet 1993 Supreme Court 353, which talks about no person cannot adopt appropriate and appropriate stand. This millet, therefore, in view of the millet submission, for synopsis and the reply, consider. Now, insofar as the interim order which expired, is to be extended to the disposal of the case. That is.
Yes.
One.
No reply for
No,
it.
because lastly, a factually inaccurate statement is made as a plan.
What is that factually? What is that factually?
He said that so far as faculty is concerned, what is done in respect of faculty is separately treated and
Teaching and non-teaching.
non-teaching faculty is treated separately. Page 64 euros.
No, how long?
64 of? 64 of the
Good purpose.
No, no, please.
He was.
No, because that fact.
And he is telling all inaccuracies.
No, because that was never put forward by him earlier also.
He was
Now, yes. So,
63.
T3.
Faculty recruitment.
So there was a faculty recruitment also with.
Yes, before the board we had.
Both teaching as well as non-teaching staff.
Yes.
Page 53.
Page 53, faculty recruitment. Board resolved to approve the proposal of the institute for releasing advertisement for faculty positions as under.
No, page 53 is the appointment order.
63.
63 is not.
It's on 58 board.
No, page 63 contains the list of.
Yes.
Huh?
Item number 58.1.
I have the list of.
My counter.
Achha, you're referring to your counter. Hmm.
63.
Yes, what?
Faculty recruitment. Board resolved to approve the proposal of the institute releasing advertisement for faculty positions as under. So for faculty positions, advertisement was issued. That is in accordance with rules. Then next page, recruitment of non-faculty personnel against vacancies. There are two categories. Board resolved to approve the proposal of the institute for releasing advertisement for 7 officers, including anticipated vacancy of registrar, and 22 other non-teaching posts for direct recruitment. Underneath that, surreptitiously this is added by internal circulation, and approval was obtained. The board merit subsequently realized that this was it was misled, and the even these posts also ought to have been advertised, and it was done without advertisement. My friend was trying to tell the court that I am not guiding the court properly. He himself was misleading the court.
So, he is the author of all these things, making it is like a man always quarrels with the truth. A man, a respondent who has taken the decision.
Now, I think these things are out. Mr. Counsel, please. I've heard the matter and reserved. Yes. Yes, since the matter is heard, not only the repression itself has been heard. Interim models are extended till the disposal of the information. Heard and reserved. Yes. Passport.
Pass over matters. Item number 18. Ram Subbarao, GP for services.
5 remaining. 5 Ramesh Chillari. Arjuna is that? Pencil.
20th kitchen. Instructions mentioned. Ramarao.
Remember?
18.
18. Yes.
That our claim is well throughout the ordinary basis. Period of good period.
So you want your representations to be considered. The sanctioning arrears of pay of duty. From 29/5/91 to 31/5/2005. What is the significance of this period?
Then what happened then? 1974, she was interviewed as selected, but post of full resident. She was not appointed. It approached Sarah report. But Sarah directed blood consultation appointment from the petition. Ultimately, she came to appointment in 1991. Those were selected in 1974. 1991, she came to the appointment in 1991 and she decided to go to the park. Then she requested thereafter, when she came to know that those selectees appointed in 1974 itself. She approached Sarah for the extension of her appointment from 1974. The trip was granted by the tribunal, page number 27. Only was allowed directing the respondent to appoint petitioners 1974 till 1991 most met. Then state different requisition votes are the court, which are elevated dismissing in year 2017. And also matter was carried to the Supreme Court, but there also thereafter in 2019, implemented order of the now fixed the pay from 1974 to 1991 personally. There is no dispute about that. I am not claiming anything from the partnership period. But actually, when I discharged by duties 1991 to 2005, while fixing the notion fixation, the RTO paid policy benefit for duty period. For 26 years, also mandates it. Therefore, I made representation to respondent to consider my case for extending the policy benefit for duty period. But they are not positive order.
Yes. The disposal of the yes. This description the petitioner is seeking a direction to the respondents to consider his representations dated 2010-2020 and 10-11-2020 for sanctioning arrears of pay of duty period from 29/5/1991 to 31/5/2005. In view of appointing the petitioner retrospective with effect from 1975 on the Leonard GP for Services 1 is also heard, having regard to the fact that the petitioner's representations are pending with the respondents and no decision has been taken thereon. This court deems it proper to direct the respondents to consider the representations in accordance with the and pass approval. Yes.
Also, item number 41, Sudhir, Chief of Service, Srinivasarao Madhya.
Yes. We got an instructions.
Yes.
Yes.
Another DAG, but of priority was placed as in charge Malkashvili.
What is this? Yes. They have some.
Itself, the very posting of another person. But in the teeth of your lordship suspension.
All right, they are entitled to file a counter. Let them file counter.
They are entitled to do
In
whatever
the
they
meantime,
like.
we'll see what is to be done. Yes.
They are entitled to do whatever they like. And also
They're
entitled-
not entitled to do whatever they like, but in accordance with law.
They are doing what the lots are saying it in this case. Where they are dealing with short products, it is in black and white. But that's what the Supreme Court said, Lord. Any interference with the administration of justice would amount to contempt actually. But now the modification by the the latest GO, for it modifies the original order. And they are saying it is said that based upon the orders passed by Lords, let me have a look at it. Using this honorable court shoulder, as if your Lords have said so. Kindly see that paragraph 5 for a minute. 1 second. 1 second.
Paragraph 5 of?
Paragraph 5. 1 second, sir. I am asking for suspension of that particular portion. Let me argue. I see your para
I
5.
like to argue, you did not.
You'll also get your opportunity. So third reference is
In view of the observations made by the, or it looks as if your lords have allowed this to happen. But whereas your lordship's order is very clear that it is totally arbitrary, but the very order of your lordship's word is referred. As if a person not reading your lordship's order dated 6/9 would show as if this is permitted. But when the order is suspended 279, and for a couple of reasons, which is mentioned by lordship and affirmed by the division bench, and when the matter is pending and the court has directed, division bench directed the requested the single judge to hear the matter with regard to implementation of 279. But what he cannot do directly cannot be done indirectly. It's a clear case of intervening with the administration of justice. Your lordships are seized on the matter is sub judice. Now, my lord, the thing that whether I am entitled for the post of Malkajgiri or not is before lordships. And now, my lord, this
See, it's not the case of your entitlement or his entitlement. It was
I'm asking
whether a posting once given without can be interfered with without notice.
I'm asking
That was the
this
issue.
request, Lord, for a particular prayer.
Yes.
Lordships have seized on the matter. There is the doctrine of sub judice. Matter is not unlike, of course, in the Tribunals Act, Lord, 1904 is there. You should not battle with it. And tribunal is created, Lord, from out of the 226. But though there is no specific mention, Lord, there is any number of judgments to say that, Lord, when the matter is pending, Lord, now what is there left, Lord, now the purpose of your lordships listening to this is taken away. And Lord, it is clearly a case of interfering with the administration of justice and justice delivery system. Now, the very meddling with it, when the matter is pending, suspended, and obviously 275 comes into force, the intention of this honorable court is that I should be posted there. The intention of the division bench chief is I should be posted there during the pendency of the report. They have not posted me. It also asked for a compliance. Then, not realizing that it's going against, or it is withdrawn. Withdrawing is understandable. But kindly see para 5.
Yes, sir.
That order, Lord, it looks as if liberty is given to him. You not speak any recall, repeatedly it was being stated. Let the matter go back to him, he will decide. What will happen, what will be my fate will be clear from the facts of the factual scenario. Lord, it is not a case
Right, we'll see.
it's not a case of malice in fact. It's a case of malice in law. Lord, the judgments are there, Lord, discussing about what is malice in law. Lord, an act done without an excuse and reason and basis. There is no mention as to why there should be a further.
Where is the petitioner working? According to you?
Petitioner, Lord, I may have to clarify this, Lord. Petitioner promotion order says, that is much more worse, says you promoted as DIG and you still continue as a district registrar. So I was drawing and working as a district registrar, being promoted with the hope that I'll get a posting. And finally, when I get this, what happened?
But where are you as a deputy registrar?
I was continuing in the same place, Lord, as a district registrar. Even now.
Even in Medchel.
No, I think. Hyderabad.
So
I just want to show.
the status quo you maintain. I'll give you 1 week's time. You file your counter. Matter will be decided. No, you have 2 weeks. Otherwise, then I'll have to pass interim. See, there is an interim application. It has to be considered. Now, because you want to file a counter, I'm giving you time. File your counter, the matter will be decided. Yes. Till then, you maintain status quo.
So already, that is what the morning, your lordship's granted time. Only asked me to get instructions regarding posting whether somebody has been accommodated, posted or not. I said I have placed the record before the lordship. Now, your lordship may kindly see what is the necessity to say all whole thing, from day one to he has been arguing the matter.
It's his grievance, he has the right to say.
Now, he has filed an amendment petition. No, please.
I'm sorry,
please, you are sorry.
Now, please.
Senior.
If you give some respect to the senior, my friend cannot tell me what I should argue, how I should argue. Number 2, If they have done 279 withdrawn, not done anything, para 5 is not added. There is the matter. When I'm challenging.
Now that is before this court. Now both of you will not speak like this. One after the other. And when this court is speaking, please quiet.
I'm sorry, Lord.
Please.
Anything I said.
No, what I am saying is, now he is entitled to put forward his grievance the way he wants to. I am permitting you also to submit whatever you want to say. Now that you know you have both submitted, maintain status quo till the next date of hearing. I'll grant you 1 week's time, file your counter. And thereafter, why? Why should, why should, see, by granting status quo, it's only to see that, you know, nobody is, disturbed. But otherwise, no, what happens is actually he is entitled to continue as DH Merchant Malkajgiri. How did you, modify that? You have to give reasons. How can you modify that GBO 275? So give reasons. You file your counter. After that, I'll consider and pass orders.
Very well.
Yes. This next week.
In fact, earlier occasion also, Lord.
Already morning I have given the status quo for morning. Already she has done it, no? In the meantime, there shall be status quo as well today.
Amendment petition
Allowed, sir?
allowed, madam. Status quo itself, date itself, 28th itself.
Amendment petition were allowed cheyaledu. Panditki వాళ్ళు counter
Oh, right.
Nothing is allowed. This next week, it's on 2011. 2011.
At least preventing this, that's why. No, he cannot prevent.
I never prevented. When we argue, always there will be cross commentary.
No, I think, please go and have a cup of tea.
We have a
Cool down.
We will anyway have. He's a good friend of mine. When I'm asking for suspension, should I not argue?
That petition is not good.
Correct, it is there. You are not seeing it.
All these discussions can go on outside the court. Please.
Take 2 IAs are filed, one is amendment, the other one is suspension. My friend is saying suspension, but it is not there.
No, I never said. Before the court, now amendment petition is there. After amendment, suspension will come into.
Suspension is also.
I have issued notice in both. For both you file your counters. Both will be decided on 30th.
Sorry,
madam.
You are both seniors enough to control your emotions. I can understand your, the pressure you have from your clients, I can understand. But you know, you are setting an example for the junior advocates here.
That's what I'm saying, Lord.
This is not the way.
Can you lordships appreciate my friend saying that I should not argue?
No, that I'm not.
Every time you're arguing, that is.
All right, now call the next case.
For seniors.
Pass over, madam. Item number 45, legal Chitralega, Chief of Services, Ram Gopal Rao.
That is actually covered by judgment of the lordships. Regarding the interpretation of the local category.
Yes.
The lordship has studied up to 6th standard in the Vijayawada, so the combined state of Andhra Pradesh. From 7th standard onwards, he studied in the state of the Telangana part of the LA state of Andhra Pradesh, present state of Telangana. In pursuance to a job notification given by the public service.
No, actually, I wanted do you have any instructions in the matter? Otherwise, this matter is covered. Last time also I said it's covered. You wanted to get some instructions.
Covered notified my lordship's order.
Yes. All right. There is no order.
No, the reason will be not that there is an observation.
That has been taken into consideration in other petition, and I have passed orders that. Then
The appeal was closed, madam, because that particular candidate paid the.
after that also another matter had come up and I had passed an order.
Yes, this is covered by same order.
Yes. Yes, similar order as in page number 81.
It was just at the same time.
Probably there is 81.
81 to 86. Will also.
The same order.
No, this is the first order. Against this only you have preferred a writ of appeal.
Yes, sir.
After that also I have passed an order, another order.
I'll pass on that order.
Now you can pass on that. That will.
Yes, my dictate the order, I'll pass you.
It's covered by other systems.
Well,
Disposed of.
Activation of list. Item number 63, Surendra Reddy, GP for services.
This is my file. So in the order for the project, when I send projecting the position, the stepping up of months of the project not in 28 plus. But the position was promoted as PGHM on 31 2009. And the junior part was appointed along with the same DSC was promoted. But on 9/11/2010, but she is not the page more page. The program is submitted to recommendation the parties for the respondent. And requesting to not give a step up. And then it was rejected with case 12 the objection. Today the ground that I should not submit the application 5 years not out of promotion of my career. Based on bring upon my memo. So it's my resolution on 12/3/2007.
So what is the time according to them?
Subsequent GPO are not even not surplus issued by themselves.
No, they say in this page 12.
Yes.
That the junior got the promotion on 9/10/2010. And you have made an application after a gap of 10 years.
Yes.
And not within the time limit prescribed with the government.
No time limit is prescribed.
Where, huh? Where is it? Where is this GO? No, where is this government memo? You have filed it along with the government. Page number 6.
The last next page, fourth time. After period government service, after phase 2 years, as per the book. But this recommendation of the government service must be received up to a period of 5 years after the promotion of their junior. Under the circumstances, such representation beyond the 5 years after promotion of the junior can be allowed.
Yes.
But also these things must, there is no references not on which is bring upon not which you or not which circular they have showed this now.
But have you challenged this?
No, one second. They are even on 12/3/2007. Subsequent, not a GO issue, not which is the page 21 in the application. Regard to this aspect. This is dated GO dated 3/4/2010. Subsequent to that time. And insofar as my.
There is no reference to this GO, circular.
Circular not supersede the GO. Government order.
Now this GO says what?
Page 22, 3C last one. Government accepted the above recommendations and definitely you have to accept C, 3C. The benefit of verification under the FR 22 shall continue to be above and promotion even if the employee has that to benefit under special grade. Still after question promotion post scale down. Because the senior law in this case and the junior, the pay of the senior should be stripped out with the effect from the date of promotion of the junior. The figure equal to the pay as fixed for the junior. Higher post to which he or she is promoted on or after control to the years of the following the conditions are given. Nowhere but the time when the perspective money is given. And subsequent to this also, page 26 in my last month. This is dated March 23/2013.
Page number
26. The government has clarified that The periodicity of chargeable deadline to scheme from 816 was reported to changing with effect from 1 to 20. And the other conditions in group was 90. Means then the three-fourths of this shall be continued. And the next, the institution officers are informed that if the happens to government created the promotion of closure of 093 so in new classification and stepping up of pay. Therefore, all the district education officer restricted to take necessary steps for implementation of the order. No implementation, explain argument. Let's take page 27. This circular also dated 14/3/2012. Second paragraph. Page 27, second paragraph. Government has found the issue in order to remove the above anomaly. Hereby order that in all cases similar to both sides of the pay of the senior should be stepped up to effect from the date of promotion of the junior. We have figure equal to the period fixed for the junior in the last higher post, which is promoted in the level on or after months of the subject to the condition in the reference first. And more than that, the time limit is fixed. By referring to the circular issued in 2007, prior to this proceeding. But they have in my case saying that I should put up the application to file.
What is the reason for the delay also? After 10 years, why are you making the representation?
Mr. may not having knowledge about that, not then after coming to you made the application. And in fact, there is a coming also.
What is this FR22B?
For a stepping up of
FR22B.
result with delay aspect to the education aspect. Now, finally, to the real point of both of the person. The effect was that it was not in accordance with the assertion of the entity or the ministry which gave which correct cause of action. Each time he has paid a salary which was not paid in accordance with the law. Whereas in the opposite, the fresh cause of action arises every month when he paid his monthly salary on the basis of the wrong computation made contrary rules. With no doubt, the offence is more correct on merits. You can entitled to be paid according to the property which in future. The question of limitation will arise for recovery in the areas for the past period. In other words, the offence claim is only for difference in its clarification. In case of difference in justice, pay which has become tempered would not be recoverable, but you would be entitled to proper fixation of the pay in accordance with the different of continuing ground. For merits, is pay to district. Similarly, there the constitution will need claims by for permission to have also subject to a difference. At last, let's take out the second medical. The pay fixation can be made only on the situation existing on 1878, it's not taking into account any other condition which may be brought in at this part of the this limited extent of the upper fixation, the application cannot be replaced when by since it is based on a recurring output. But when subsequent circulars are more doesn't say about time fixation. It was up in the application within 5 years. So they can't get my case. Basically, a circular which strong claim supersets with the government order ensured 2007. That is the only point.
Yes.
Memo dated 12/3/2007. 5 years period. Case number 8. Memo issue. That is all the 1/21/2020.
What is this memo?
of pay of the senior government servants, along with the pay of Desh Union as per rules. The request for representation of the senior government servant must be received up to a period of 5 years to the promotion of their junior. The no circumstances such representation beyond the 5 years after the promotion of their junior can be 20th January 2020. Page number 10 minutes, 0-40.
This is of 2002. What is its relevance?
He raised the question that the DO has no power because related to pertaining to TSHC. Therefore, it's only for the second. For that purpose, they so that
What was your place?
page 11,
Third respondent is not competent authority to pass the order.
has to refer to
Delegation of powers to various functionaries, namely headmasters supreme. So there is a delegation of power to third respondent to pass an order. For that purpose, yes. That's all. Huh?
Page number 2 of my regarding the answer submitted dated 7/5/2000. Educational officers shall have the power.
All right, this is with regards to delegation of powers. All right. That's all.
my questions are issued by the director of business and courts, not issued by the government. From the counter. And there is refer by not 93.
UMS number 93 is
Does not refer. 93 is not
prescribing the period of
page 21.
5 years.
There is no such standard case which we give. Page 21 by the
2010.
We said that not and we try to comment on public my junior on the day of promotion.
So it's only the circular which prescribes the period of 5 years. No GO refers to any period. Any period.
There is several circular, it doesn't refer anything. Case 6. Doesn't refer any of the circulars are used for case 6. Just 2007.
These are the clarificatory instructions.
Subject and no reference at all.
So clarification of what did you give in this?
Rules are clarification.
No, but clarificatory, you are saying clarificatory instructions. In respect of what? What clarification?
That to 2007. Subsequent to that, the circulars were issued, GO were issued. The guidance part shows that time is
GO 297, 83, 182.
Page 26 and 27 circulars also doesn't this is the value issue subsequent to this circular.
They say most often people file applications after 20, 30 years ago. It's very difficult to verify. And that's why they are fixing this period of 5 years.
They may know that the junior month is more for the appointed run, then they can't. Senior also
I'll consider and pass it.
the request is not in December. But most is not, he has to play in the regular evening service. He had not finished.
All right. Third result.
Item number 64, Vikram Chandra, Chief for Services.
The issue involved in the present is not easy of the retirement and other questions.
Instructions తీసుకుంటాను జీపీ గారు పిటిషన్ కౌన్సిల్
She was here yesterday. Why was it adjourned yesterday?
Yesterday, my colleague has requested for making it password of the lunch notes.
Okay. Counter is filed.
Council has filed. No.
Yes. What is it? What is the relief that you're asking?
See, facts in a nutshell are
Not considering your representations for retirement benefits, PF, gratuity,
Yes.
pension of her deceased husband.
Yes.
So,
So far as the facts are concerned, the husband of the petitioner was initially appointed as a lower division in the year 1965 minutes. Subsequently, he was voted in the year 1972. While he was in service, there was an allegation of theft and typewriting of a memorandum of marks. On that ground, my lords, he was suspended in the year 1978, which facts has not been disputed with the respondents in the counter affidavit. The main grievance methods, it is relevant to be noted here, page number 7 and 8 of the counter affidavit. It says that I have been continuation in the service. There was a criminal case registered against me. The judgment came on 30th of September 1991. Thereafter, no orders have been passed, neither submitting any substantive evidences, my lords. My application, disciplinary proceedings were also initiated.
No, when did the petitioner's husband die?
He died in the year 2013, my lords.
2013.
The age of superannuation of the petitioner's husband would have been in the year 2001. This fact has been admitted by the respondents.
But he was placed under suspension when?
He was placed in the suspension in the year
16/1/1978 and he was dismissed in 2018 after his death. After his death. After his death.
After his death. My presentations are very clear to the extent of stating that I may be released with a certain benefits. The representations have been given by us in the year 2013.
Now they have terminated with effect from 30/9/1991.
Yes, my lords. With a retrospective effect. The said order, my lords, my grievance is that if the petitioner's husband would have been alive, definitely he would have challenged the dismissal order. But there was no such order was passed during his lifetime. Second grievance, my lord, it says that he has been dismissed from service on account of the criminal charge of conviction. But that statement is not applicable here because once an employee has been when the disciplinary proceedings has been pending and if the employee died to minors, then it amounts to the proceedings has been presented in abated. That's what Rule 54 B of the civil CCCA rules states. So as per the well settled law, minors, submitting the settlements, it says that there is a GO which has been passed by us. The GO says whenever if you have wanted to dismiss any such employee pending the disciplinary proceedings, such order has to be passed forthwith, even though when a nominee has also been deferred. You could have, but no such steps has been taken into consideration because they have not taken any such steps. Finally, when I have been persuaded with the presentation, they have come up with the present dismissal order, which itself is not liable to be sustained. Because I have not challenged, I am not challenging the said dismissal order, neither I am going with that. My simple case is that the disciplinary proceedings, it has not been concluded when the employee was alive, then the said proceedings is deemed to be abated. That is my only case, fellows. Based on this, me being the wife of this deceased employee, my lords, we are entitled for all the benefits. Coming to the rule position, my lords, there is a
Which rule?
My lords, that is a circular.
Payment of subsistence allowance.
Yes, my lords, payment of subsistence allowance. Now page 229, my lords. 229 now. 227. 27, point number 2.
227.
Point 2, my lords, it has been marked. 227.
It's part of Lemon and this one.
In case where the penalty is imposed. Page number 227.
Yes.
The second point. It says, in case where the penalty imposed on the basis of the conviction was dismissal, removal, or compulsory retirement from service, the order should also state that under Rule 34 of the Andhra Pradesh Civil Services CCTA Rules 1963, the government servant is deemed to be under suspension with effect from the date of dismissal, removal, or compulsory retirement from service. There was no such order which says that the procedure contemplated under Rule 34 has been followed. Subsequent to this, my order, page 226.
What is this? I didn't understand this.
Payment of the subsistence.
In case
it says that whenever any employee has
penalty imposed on the basis of conviction was
Yes.
dismissal, removal, or compulsory retirement from service, the order should also state that under Rule 13(4) of the AP Civil Services Rules, the government servant is deemed to be under suspension with effect from the date of dismissal. One says already from the date of dismissal, removal, compulsory retirement. Why should he be deemed under suspension?
I'll be showing the citation, my lords, which is says the interpretation of this Rule 34.
There seems to be some mistake here in the printing or whatever.
Last second page, my lord.
Maybe it should be not with the, till the date of dismissal.
Yes.
Okay. To have another copy.
Rules.
Rules.
Last second page, point 3.
226. Page 1. Same on the Rule 25.
Point number 5, my lords. Last second page. It says it is when second that quoting provision cannot invalidate the order as such. Point number 5, my lords. Last second page.
You have to read the whole thing, whole paragraph to understand what this means.
The facts are written in this present case.
Where are you reading? What are you reading? Now, what are you reading?
This is the citation copy which I have submitted.
No, you are referring to Rule 25 and the instructions there. So that he should be deemed to be under suspension. That paragraph you have to read the entire para
The
2.
whole circular has to be pointed out for your lordship.
Para 2 of that circular.
My lords, the said circular is which I have said this now. It will be there at page 228. 228. Your lordship.
Yes.
Payment of subsistence allowances. Further
It's just India. Am I good? So what you are saying is because he was dismissed from service after his death, he should be considered to be under deemed suspension only till, and he should be paid subsistence allowance and also the benefits after his terminal death. That is your prayer.
Yes, ma'am. He was not being dismissed from the employment. immediately after the disciplinary proceedings has been concluded. Only issue, my lords, once he has been, the order itself of the dismissal says that as he has been convicted pursuant to a crime, invoking the rule 9, the major penalty has been imposed by dismissing him from the service. My lords, law is in such a way which says that whenever we wanted to impose major penalty, like by dismissing the service or by reducing a rank, then in those circumstances, the said procedure cannot be acted arbitrarily. They should be the reasons which has to be detailed mentioned. Here, my lords, when the circular prescribes that he has to be dismissed, if at all certain decision has been taken by the government for dismissing an employee basing on the conviction charge, then such a decision has to be taken forthwith. What made the respondents for not taking such a decision? If such a decision has been passed on the employee would have been challenged when he was alive. Now, my lords, second grievance is that, my lords, it has been stated by the citation which has been passed on to your lordships, right? It is a division by citation. It has been written by now. So, whenever the same proceedings have been getting awaited and all, once a person has attained the age of superannuation, then in those circumstances, whatever the benefits are there, it has to be given. You cannot dismiss such person after the attainment of the age of superannuation. There are certain rules and regulations which have been designed. All those rules has not been followed in my particular case. That is my humble submission. Now, my lords, the citation which has been passed on to the lordships indicates the same. Basing on the charge of misappropriation, he was dismissed from the service. When he was challenged, by the time the order came, my lords, the dismissal, he was already said to be retired based on his superannuation of age. The relevant portion, my lords, is at last para, my lords, point number 5. Point 5. It is well stated that quoting a wrong provision cannot invalidate the order as such, but taking a close look at Rule 9, one of the rules also, the same will not go to the gate of the government, inasmuch these said judicial proceedings ought to have been correlated to the status of the petitioner as a pensioner. Admittedly, in this case, the petitioner was not a pensioner when the judicial proceedings were initiated, and in fact, he was convicted when he was in service. And even after conviction, he was continued in service till his retirement for the reasons best known to the government. Therefore, the government, having failed to initiate action by invoking Rule 25 of APCS, CCCA rules for terminating the service of the petitioner, it precluded from initiating any action when he becomes pensioner in the guise of the judicial proceedings, finding him guilty of misconduct. Thus, viewed from any angle, the order of the government is not sustainable in law. It is also doubtful whether having paid the entire pensionary benefits and the gratuity to the petitioner after his retirement, question of withholding or withdrawing pension would not arise in this case at all. Here, the pension was withheld, my lords. However, my lords, with regard to my facts of the case, as the proceedings has been abated, that is what my humble submissions. I will be passing a compilation of the memo, my lords. This covers 2 citations of our bench, my lords, and 2 other citations of the honorable exporter. Page 4, my lords. Paragraph 14.
Yes.
It is relevant to note that this rule came into existence only in the year 2006. It deals with a situation where the employee was neither charge sheeted nor called upon to explain why the loss caused by him should not be recovered prior to his retirement on them. It does not deal with the situation of an employee dying during the disciplinary proceedings, thereby rendering the same incomplete. Any event, the said rule have no retrospective effect and cannot be applied to the facts of the present case. As the charged officer admittedly died in the year 1999, the findings recorded by the inquiry officer in this report dated 2000 and the subsequent action of the disciplinary authority in directing recovery of sums based on such disciplinary proceedings cannot therefore be deemed devoid of legal action. Insofar the period of suspension undergone by the charged officer from 1998 to 1999 is concerned, please so that comes in place strong reliance on fundamental 54B. It is this case that the state would be squarely applicable to the case on hand, and the respondents were not justified in denying the benefit thereof to the petitioners on wholly untenable On the other hand, learned students of standing counsel relying on the fact that the charged official was reinstated in service upon revocation of the subsequent of suspension prior to his death, contended that the said rule would have no application as per its clear language. Fundamental Rule 54B has been extracted. Notwithstanding anything contained in Rule 53, where a government servant under suspension dies before the disciplinary or the court proceedings instituted against him are concluded, the period between the suspension and the date of death shall be treated as duty for all purposes, and his family shall be paid up the full pay and allowances for that period to which he would have been entitled had he not been suspended, subject to the adjustment in respect of the substances allowance already paid. The thrust of the rule is, as is apparent from a plain reading thereof, is that if a government servant dies before conclusion of the disciplinary proceedings, his period of suspension shall be treated as on duty for all purposes, and his family will be entitled to pay full allowances for the said period, merely because the rule refers to a government servant under suspension dying before the disciplinary proceedings are concluded. It would not exclude those whose suspensions would revoke, but who died prior to the conclusion of the disciplinary proceedings. A contrary view would be distinction or disparity being drawn between the government servants against whom disciplinary proceedings did not conclude prior to their death, only on account of their suspension being continued or being revoked prior to death. Such a classification would be neither rational nor reasonable and would be violative of Article 15 of the Constitution. The period of suspension undergone by such an employee must therefore be treated as on duty. The emphasis of the rule being on the incomplete disciplinary proceedings at the time of his death. The charged officer in the present case, having died before the conclusion of the disciplinary proceedings, would therefore fall within the protective umbrella afforded by the aforementioned rule. The action of the respondent in creating the period of his suspension pending such incomplete disciplinary proceedings as on leave therefore cannot be counted.
All right. What is the next judgment?
Sorry, my lord.
What is the next judgment that you have?
The next judgment, my lord. Page 7.
About the abatement of the disciplinary proceedings after the.
Yes, my lord.
All right, yes. What
Page 7, para number 6, my lord, as well as 7. Para 6, 7, and 8.
And you are also relying upon a Supreme Court judgment.
Yes, my lord. The relevant para of the page 14, my lord. Here I would like to explain the relevancy of this citation to the parts of the present case is concerned. My lords, here para 14, the first unnumbered para. It says that the second line, para 14, second line, first unnumbered para.
Page 14 or para 14?
Page 14.
Page 14
Page
doesn't
14.
contain para 14.
Yes, ma'am.
You are reading para 4.
Number first para. Number first para. Page 14.
Yes.
It says like this. It says, accepting the plea the learned magistrate has convicted him under section 409 of penal code, but in view of the peculiar circumstances of the crime and the criminal, he was released under section 4 of the provisional Act. May not see why I am writing this judgment is the similar case, based on the conviction, he was dismissed from the service, stating that Article 311 of the Constitution provides that whenever any person has been convicted in a criminal case, it has to be dismissed. May not the ground which your lordships have stated and bracket here is nothing but you cannot impose any punishment simultaneously for one single person by dismissing him from the service as well as the conviction. Whenever you are passing such an order of the conviction, it has been emphasized to members that the department should act justly and fairly. That paragraph has been extracted at page number, para number 7 members. Para number 7, page 15. 7 and 8. It has been stated, it should be noted that despite the observations of the magistrate, the government chose to dismiss the appellant without applying its mind to the penalty which he could appropriately be imposed upon him. Insofar as his service career was concerned, clause 8 of the second provision to Article 311(2) of the Constitution confers on the government power to dismiss a person from service on the ground of conduct which he has led to his conviction on a criminal charge. But that power is like nothing any other power has to be exercised fairly, justly, and reasonably. Surely the Constitution does not contemplate that a government servant who is convicted for party distributed in the non-party area to be dismissed from service. He may perhaps not be entitled to be heard on the question of penalty. This is clause A of the second provision to Article 311(2) makes The provision of that article is applicable when a penalty is to be imposed on a government on the ground of conduct which has led to its conviction on a federal charge. But the right to impose a penalty carries with it duty to act justly. Considering the facts of the case, there can be no two opinions that the penalty of dismissal from service imposed upon the appellate is justified. Accordingly, we allow the appeal set aside the judgment dated dismissal and add that appellant shall be reinstated in service with the full back wages from the date of his dismissal till reinstatement. Here, my notes, the so far as the punishment is considered for the offense 409 on which the Supreme Court has set aside this dismissal order. It is of nearly imprisonment for life members, which may be extended to 10 years. Here, my notes, the offences for which the deceased was the so convicted. It was only for 6 months plus 6 months for 3 offences and 1 year. Moreover, my lords, he has already undergone that punishment also not disputed. Now, I am not challenging the dismissal order, my lords. My details is that when he died, the said proceedings ought to have been abated. A pensioner cannot be proceeded with a dismissal order, my lords. In these circumstances, the family of the petitioner is entitled for the family pension. So, with this observation, I request your lordships to pass me.
Yes. You want time to go through the Supreme Court?
My lords, it is very clear in the case, sir. It may be the action of orders.
Orders tomorrow.
Orders.
Item number 65, Arvind Reddy, Chief of the Services.
Notice has to be issued.
Well, I will not press that petition.
IA, you said yesterday already that you are not pressing the IA.
IA and the intake petitioner.
You are not going to press intake petition.
Yes. Because the very IA is dependent on the split petition or filed based on the pleading in the IML. In fact, I have thought for set aside of 2 GOs and I have misread the 2 GOs under which they are the subsequent GOs to another GO. I didn't have the copy of GO number 38.
Is that you are challenging in this petition?
Yes, sir.
You are challenging recommending the name of the petition, not recommending the petition.
Yes, sir.
Ad hoc promotion and promoting juniors and other colleagues of the petition.
Yes, sir. These GO number 541 and 542 are subsequent to GO number 38 and 39.
What are these 541, 542? These are the promotion orders.
Yes, my lord. Directing.
Posting orders.
Posting order. Now, my lords, I am not pressing for any relief against the people who have already been promoted. I am boiling down my prayer to only a limited purpose of considering my candidature for ad hoc promotion as applicable under GOMS number 257. My lords, admittedly, my candidature was not considered only for the fact that there are disciplinary proceedings pending against me. Whereas, my lords, as per GOMS number 257, even though the proceedings are pending against me, I am eligible for ad hoc promotion. My lords, may kindly peruse the GOMS number 257.
So now you don't want to press your IA for including the other.
Yes, ma'am.
So that has to be.
Yes,
ma'am. Yesterday you did not press IA 1 also, seeking interim relief.
Yes, ma'am. I am not pressing for any interim relief.
IA, what is IA 2? IA 2. Implementation. Internet Council for the Petition Submit.
Purpose is very limited purpose, doesn't even need a counter. Already a order of this honorable court is in my favor.
Consider case in terms of 257.
Yes, sir. For ad hoc promotion, not for regular promotion.
Request counter because in the court, not for the restriction we not fight. Here we not mention fight.
That was challenging my regularization, my lord. That was a specific order which has not been followed by the department.
specialty 4303023, 24585 of 23. 27956 of 23.
There are 3 petitions filed by him, but must be for different reliefs.
Yes, my lord. Obviously.
Can't be the same.
One of the petition is disposed of not to consider this case for promotion.
Promotion.
No, my lord, that is not for promotion, for regularization, my lord.
Have you included those order copies?
Yes,
here?
my lord. It is a page number 100, page 100.
Please come back.
Relevant portion is at 101, my lord.
Case of the petitioner for promotion as superintending engineer. Now, what is the post that you are asking for now to be considered?
Ad hoc promotion, my lord.
Ad hoc promotion as well.
As a superintending engineer.
So for the same relief, you have already filed a writ petition.
No, my lord, this is for regular.
Not for ad hoc, maybe, but for promotion as superintending engineer without reference to charge memo issued to him by GORT number 148.
Well,
What is the GORT 148?
148 is a charge memo issued to me.
So here we are not asking, here also you are asking same thing. Pending disciplinary proceedings, GORT number 148.
Well,
So for the very same relief, how can you file 2 writ petitions?
well, this writ petition has been disposed of with a specific direction to consider my representation and take action in accordance with law. When I have given my representation, they don't consider it. They promote all my juniors.
No, this is dated 3rd January 2023.
There is a specific direction, when I page number 101. In view of the submission made by.
So your representation has now been disposed of?
No, well, the representation is not even considered. Forget about disposal. It is not considered because there are two contentions of mine. I am working as an in-charge executive engineer. First, I need to be conferred as a regular executive engineer, and then I will become eligible for promotion as superintending engineer. Well, a GO number 283 has been released, regularizing all my juniors. Though my seniority has been considered in a subsequent previous proceeding that I will be eligible for regularization as an in-charge EE to EE, that has not been done, showing that there are disciplinary proceedings against me. Whereas during the relevant period where my seniority is being considered, no disciplinary proceeding was pending against me. The same had been given in my representation very clearly. That has not been considered.
Not considered.
Not considered. Against which I have filed 43030, where there was a specific direction to consider my representation and consider my promotion as well. That has not been given a go. My promotion, the representation is not considered, and all the people who are eligible for promotion, who have been regularized under the said GO of 283, they have been further promoted to further posts. These have been conferred EEs have been conferred SC.
Alright, you get instructions whether you have, when there is a direction to dispose of the representation. Why you have not disposed of the representation? And the petitioner's case is, can be considered under 257.
Earlier, cadre has to be regularized, that is also pending, the petition 430.
43030 is to dispose of the representation only.
43030 dispose of, that is not the right to a writ petition.
But with regard to the with regard to this clear service with regard to the charge engineer has to be regularized first, thereafter only this candidature can be considered for further
Promotion as superintending engineer.
I found out.
What is, it's after 2 weeks, 3 weeks to count.
Right.
Item number 66, Ramurthy, Venkatesh Gupta.
My lord, the petitioner's husband was a employee of license. And during 2016, while in service, he suffered great hemorrhage. And due to that, he was
restricted to wheelchair only. So he has given a representation memo, which can be seen at page number 17. He mentioned in the representation stating that he may be retired from service in the year 2016 December month due to my ill fate. Suddenly I underwent a hemorrhage brain stroke as a left side of my body lost movement by attaining severe paralysis. So from then I am on bed, unable to move and do my own work. So I request your good self to allow me to retire on medically unfit grounds. So he has categorically mentioned for unfit on medical grounds, and according to the department, right, in page number 18, then he directly have mentioned that your representation dated 31/3/2018 requesting for supervision on medical grounds and the certificate data issued by Dr. Hanupala declaring that you are suffering stroke and hepatitis and that you are disabled and accompanied wheelchair. This correction you are hereby advised to undergo medical examination by Dr. R. Srinivas. Accordingly, he has underwent to that Dr. R. Srinivas. And R. Srinivas also has said that he is confined to wheelchair. In page number 26, my lord. Page number 26, he has mentioned that now patient is confined to wheelchair.
Okay.
But the department, instead of giving him the medical follow, they issued a letter to him, which is at page number 23, my lord, stating that at page number 23, my lord.
Yes.
This has reference to a letter dated 31/3/2018 of the above officer requesting for VIS and medical grounds and to provide employment. Please second, sir, Mr. Arun. In this regard, I inform the zonal office that request for VIS conditions cannot be entertained as per staff regulations 1960. My lord, he is actually, after suffering with brain hemorrhage, huge amount was spent for his treatment, my lord, and his dependent son is unemployed to take care of the family. He has requested for a medical follow-up. And there is, as per the LIC service rules, my lord, at second page 19.3, rule 19.3, my lord. Nothing contained in the following sub-rules shall affect the right of the appointing authority to retire and employ without notice of the due thereof is being verified by medical examiner to nominate for purpose the appointing authority as being incapacitated for continuous service due to continuous illness or accident. So as per the 19.3, they have to retire him from the service. But my lord, the impute order at page number 16, my lord, this says that the decided that your voluntary retirement is deemed accepted with effect from 28/9/2018 under section 19.2. Instead of 19.3, LIC rules, they have given him they have retired him from service under 19.2.
AB. 2 capital A, capital small b.
Therefore, its impute order is arbitrary, my lord. And the employee has put up 28 years of service in LIC.
What is this 19.2 AB?
19.2 AB is page number 2, my lord.
Yes.
That notwithstanding what is stated in sub rules, an employee may be permitted to retire any time on completion of the age of 55. That is for general.
AA. That is B.
That is for general, my lord. And whereas for 19.3, it is for the medical grounds. So they should have considered his representation for medical grounds because they have even referred him to the medical doctor for examining him. And after the examining, they would have considered his representation for on medical grounds, my lord. But instead of that, arbitrarily has given him the voluntary retirement.
Now, if he retires under 19(3),
Yeah, madam.
then he is eligible for
Compassion appointment.
compassion appointment. Where is that? That's
But medical product, it's a medical product, so who is
the compassionate appointment. Where does the service rules provide for compassionate appointment?
normally in the medical product, madam, my lord, there will be compassionate appointment is an opportunity given to the dependents, my lord.
No, the rules must provide for it. Where is it? Have they said anything in the counter?
Hello?
In the counter filed by them,
Yeah.
have they said anything about the compassionate appointment?
No, my lord, they have not mentioned.
So here the petitioner is the wife of employee. Now, what is that you are asking for the benefits only, death benefits?
I'm asking for the
terminal benefits.
compassionate appointment, my lord.
No, your prayer is only to release
Yes,
the
terminal benefits also has not been released, and as well as for the compassionate appointment also, my lord.
in your prayer, there is no reference to compassionate appointment.
Where is the compassionate?
Where is the prayer? Please read.
Yeah, my lord. My lord, page number 15. This other prayer that they always want the place to grant native direction to the second response consider petitioner's son, namely Kota Arun, for suitable employment and compassionate grounds.
There are two consequential prayers. Sir.
Yeah.
లేదు ఒకటే ఉంది పిటిషన్ లో ఒకటి ఉంది అఫిడవిట్ లో ఇంకొకటి ఉంది ఫర్దర్ ప్లేస్ ఎట్లా పాస్ చేస్తారు పిటిషన్ లో ఓన్లీ వన్ కాన్సిక్వెన్షియల్ ప్రేయర్ అఫిడవిట్ లో కాన్సిక్వెన్షియల్ ప్రేయర్ తర్వాత అమెండ్మెంట్ చేస్తారు Only the petition number 2 is included. There is no amendment of prayers. In the prayer, in the writ petition, your consequential prayer is only to pay the terminal benefit. In the affidavit, you have made further prayers. They are not supported by any.
In India, I have mentioned.
Which IA?
IA 1, madam.
IA 1. IA lo. IA lo.
Page number 15.
Yes, what do you have to say?
But in the prayer, the main prayer, there is no prayer, see not appointment of company. They constitute the prayer as an entry result, as a final prayer. But in the entry petition, there is no such prayer for grant of
of compassionate appointment.
Compassion.
Because the annual benefits is granted. We have already communicated in your last week and see my counter and with material papers. $22 million. Page number 21. 21 is the order. Waiting him to retire on medical clause BRS. Page number 21. Communicated to the decision below. Page number 22. On 11/3/2000.
No, 21 is his request for superannuation on medical grounds. 22 is not on medical grounds. You are just accepting his application 19(2)(a).
The request is on page number 21 and consideration is on 22, page number 22. It is received on 23/2020 by the decision. And subsequent thereafter he died. Even that is also communicated and retirement benefits, BRS benefits also communicated to him. Page number 23, 24 and 25. It is on 21/3/2020, including all the forms required for BRS and paying the benefits for paying. Subsequently thereafter, he died on 28/4/2020.
This is one of the issue of the.
We are asking for them to submit the forms.
Yes, I would also Lakshman kindly see the page number 26, 27, 28, 29, 30, 31. Recently, the postal powers which was sent by the corporation asking them to submit papers.
Is this the same address as given now in the request?
Yes, they are not disputing the same in the regard of anywhere.
I'm not disputing about the double benefits, my lord. But our request is only for the compassion department, my lord. Because in the impute order, they have given the representation dated 28/6/2018, my representation. In that representation also, I have mentioned that.
No, the thing is.
Department given to your son.
1 minute, sir. I do not know whoever has drafted the requisition. In the main prayer, you have not, you are asking for only the consequential benefits by treating the deceased employee as died while in service. Okay, terminal benefits. And additional prayer, that too only as an interim measure, you are asking for compassionate appointment to your son.
My lord,
There is no reference to that in the main prayer.
I have mentioned, my lord.
IA is only interim measure, no?
As I said, amendment for this, my lord, because compassion department is required, and this is employee also has given mention that this request was for the compassion department only, my lord. Even the date, even the application.
All right, I'll give you time, whatever you want to do, you do. I'll give you some time.
Time of test is already permitted to be received by him.
2 weeks time have been given, my lord.
All right, 2 weeks.
Item number 67, Shankar, Kali Praveen Kumar, Lakshmi Narasimha.
For the pension for the application made by the petitioner as per the circular dated 4/2020.
Who is the respondent? Who is the respondent? Bank, sir. Union Bank of India. Who is appearing for the bank?
Lakshmi is my counter.
Dr. Srinivas. Yes, what is your prayer in this question? Pension scheme to the petitioner as the so and so.
Yes, directs the respondent to consider the application made for the pension scheme as per the circular dated 4/6/2020.
So there is an impugned order rejecting your case. What is the reason for denying you the pension?
They are saying that we are delayed in filing the application.
So what is the time limit, time prescribed for filing?
That was your lordship 60 days. That is from 4th June 2020 to 2nd August 2020. We have applied an application on 20 September 2020. The circular was issued in deep COVID period, Your Lordship. There was no intimation given to the petitioner, even though the respondent was having all the personal information, contact information, and the address of the petitioner. No information was given. So when later the
He had already retired by then. He
Yes,
had retired.
he got compulsory retired in 1997, and the pension scheme is for the all the people who retired from 1995 to 2010. It is mentioned in the circular, Your Lordship.
Yes.
Page number 15. In the counter, it's also, Your Lordship, they have agreed that we are rightly entitled for the pension, Your Lordship, but because they have delayed in filing the application, they are not considering it.
Where is the time prescribed here in the circular?
Number 15, page number 18.
Hmm.
.1 clause, Your Lordship.
Ah.
No prejudice in the cost of the respondent.
So will commence from 4/6 and will be closed on 2/8.
Yes, Your Lordship.
After submission of additional candidate. Yes, what are they saying in the counter? The same reason.
Yes, Your Lordship, they're saying that we have delayed in filing the application, but the delay was due to we were not informed about the said application, having the scheme, and moreover, the petitioner is residing in New Zealand. So getting this information was very difficult for the petitioner also, and it was the deep COVID period. The Lordship, as per paragraph number 14 of the circular, page number 19, the circular clearly mentions that cooperation of all staff members is solicited for timely exercising the option and are further requested to publicize or canvass the information to all concerned. That all eligible compulsorily retired employees or family members of deceased compulsorily retired employees get the benefit of the scheme. But no such intimation was given to us, Your Lordship. But as soon as we got to know about it, we have applied for it. We have delayed of 49 days, Your Lordship, but it was a COVID period, and as per the Supreme Court guidelines, the Supreme Court has stated that the period from 15 March 2020 till 28 February 2020 shall stand excluded.
Yes. What are they saying in the counter? Let us see the resolution.
The Lordship may see in reply to para 5, that is para number 11 in the counter. It states that it is true that the petitioner was also entitled to exercise option for pension in terms of the circular number 7116 dated 4th June 2020 issued by the bank. Since his compulsory retirement from the service of the bank was on 31st December 1997, that is during the period between 29/9/1995 and 27/4/2010. But the option was to be exercised during the period between 4th June 2020 and 2nd August 2020. But the exercise of the option by the petitioner was beyond the cutoff date, and hence it was rejected. There is no dispute in regard to our eligibility for the pension, Your Lordship. It is just a delay in filing the application.
Where is the Supreme Court judgment that you were referring to?
Memo of citations. The first citation. It is further clarified that the period from 15 March 2020.
Page number?
Page number, Your Lordship, is
Para?
5.4.
5.4.
Your Lordship may even consider the third citation, para number 21. In Nagarjun Rao versus Under Secretary FFR Division. In that, it has been stated, Your Lordship, action is right, not a bounty. In a broader significance, it is a measure of socio-economic justice which enhances economic security in the fall of life when physical and mental capabilities of a pensioner begins to act corresponding the aging process. The reason for grant of pension is the inability to provide for oneself due to such old age. This can be withheld, curtailed, or taken away only in accordance with law. Every mental prowess and physical incapacity due to age was one of the prime reasons why the certificate could not be submitted in time. This is the peculiar facts of this case. By no stretch of imagination can be construed to take away the right of the petitioner for grant of pension, particularly in the teeth of the guidelines. Therefore, the Union of India and the bank ought to have paid arrears of pension to the petitioner and not driven the petitioner to view preceding analysis. The petitioner is held of pension.
Yeah, the petitioner was 1 or 2 years.
So he lordship is 68 years of lordship.
The petitioner is seeking a direction for the respondent. He is seeking a direction to the respondents to application. Rejection order is there.
Yes, actually, the respondent council have mentioned for the amendment of the prayer, so therein we came up.
So they have rejected your request at that after filing of the writ petition, your application was rejected by giving reasons. So that also is challenged. So the petitioner is challenging the rejection order. And retired, compulsorily made to compulsorily retire from service in the year. When did you retire?
1997.
The year 1997.
We decided it was
31st December 1997. We submitted that the respondent bank has issued the pension scheme by staff circular number 7116 of 116 dated 4th June 2020 in respect of to the employees on 29/2020. On the ground that the said application is beyond the period prescribed in the circular, the application of the petitioner was not considered. Full stop. Challenging the same, the present declaration has been filed and subsequently the application of the petitioner was rejected by the order dated 5/11/2020. The petitioner has amended his prayer accordingly and is challenging the rejection order. The Internet Council for the petitioner submitted that though the pension scheme was introduced on 4th of 2020 and it was prescribed that the applications have to be submitted before 2/8/2020, it also provided that the said scheme should be canvassed or publicized to all concerned so that all the eligible compulsorily retired employees
Kindly, I'm sorry for the interruption. My name may be recorded, Madam, because I was held up in other court. I couldn't come. For 67. I'll be grateful to you.
Right, yes.
I was
directed for reconsideration, my lord.
Yes, yes, directed for reconsideration without reference to the period of that limitation period that you have prescribed the last date.
Great. I'm very grateful.
Yes.
Number 68, Hanumantarao, Kadi Praveen Kumar, Srinivas.
If you take half an hour,
We'll continue tomorrow. It will continue in the same list tomorrow. It will be on the top of the list. Tomorrow. Extension of interim orders ఉన్నాయా?
Not in serial లో ఉంది. Interim order minutes to expire అయిపోయింది. Interim order
ఏది item number?
109.
109. Okay, take it. Just put 5 on that. Counter వచ్చిందా?
R4 మీద.
Request. Are you appearing for the respondents? So you want to mention another. The counters are yet to be filed. The list after 4 weeks. In the meantime, the interim order.
My lord, I have filed this day this petition, my lord, first and day after tomorrow, my lord.
73. No, he had asked for time and granted 10 days time, 73. In the morning, he mentioned.
Day is there, my lord, I have filed vacate petition, my lord. Without informing me, they might have.
Order extend చేయలేదు. Interim order extend ఏం చేయలేదు.
Extend ఏం చేయలేదు. Only 10 days, posted after 10 days. 73.
73, my lord.
Yes, Mr. Prithviraj Mudrundu is the
Informed me, my lord, I have filed vacate petition, my lord.
He asked for time.
My lord, will proceed day after tomorrow, my lord.
No, but I have not extended the interim order also. Just maybe చేస్తుంటాం.
There is no interim order, my lord.
లేదా
చేయలేదు.
usually on a day, we'll post it on Monday, Tuesday. Okay, you inform the other side, I'll get up on Tuesday.
Day after tomorrow, senior council is appearing, my lord, vacate petition.
Who is the senior counsel? Who is the senior counsel? He's here only, he can appear on Tuesday also. On Tuesday. Please inform the other side also. He has not informed you, but you please do. Which one? They'll come tomorrow. This will continue, you're watching it and then, yes.
Item number 164, item 79.
You want after 10 days? You are for the petitioners? Okay, 79 after 2 weeks. Monday week.
Subject to your lordship's kind leave, my lords.
Yes. Yes, madam.
Item 78, my lords, beg to represent Parma Reddy, my lord, for respondent counsel. We've already informed the appellant counsel, petitioner counsel, my lord, request 3 weeks time for filing our counter, my lords.
Okay. Less, after 3 weeks.
78, my lords.
78, yes, yes. Yes, any other mention?
168 tomorrow.
Obliged.
168.
168 will come in the list.
Tomorrow.
Not tomorrow, it will be in the list. Continue.